Good morning to the bar after a long time.
May I, Your Lordship?
Yes,
I beg to mention listing of one writ appeal.
listing, please give it to the court master because they may have to make some adjustments. Correct, there is a long list I am told. Please give it to him, we'll make some adjustments. May not be on the day when you are wanting. All the prayers for listing, give it to the court master.
Malat,
Yes.
may I pray, Malat, item number 8, Malat.
8,
Can this be taken after 2 weeks, Malat?
8. Okay, no issue,
Yes.
22, madam.
Pleasure.
You want it on Thursday?
After 2 weeks, Malat.
After 2
Yes.
weeks, okay. You have informed the other side?
Yes. In the morning itself.
Okay. With consent of the other side, Mr. P. Taful and amicus curiae. Praise for adjournment, prayer is allowed, list after 2 weeks.
Obliged.
May I, Your Lordship?
Yes,
Lordship, I beg to mention item number 11, Your Lordship. This matter may be listed on 22nd of January, Your Lordship.
this is PL 23.
Yes, sir.
Just let me have a look at the file. 23. There is something.
Mm. Yes, Your Lordship.
Yes, Lordship, I have no problem, Lordship. Moreover, I have to file rejoinder again.
Yes, we have, for respondent number 2, we have filed our counter affidavit, Your Lordship. Yes. And for three.
Lordship, the affidavit filed by 2 will cover 1 and 2, Lordship. And on behalf of 3 may not be required, Lordship. Lordship, we can proceed to hearing also. On 22nd of January, Lordship. January, because learned AG is appearing in this case, Lordship. He is requested if it can be fixed on 22nd, Lordship. Lordship.
P. Pangu, Your Lordship. P. Pangu. Yes, Your Lordship.
Lordship, I would like to mention item number 1. Lordship, I kindly take up this matter after 2 weeks. Lordship, I have taken the consent of the petitioner. Respondent, Lordship. Yes, Your Lordship. Arbasari, Lordship. Lordship. Government Advocate. 2 weeks.
My
Yes.
pleasure. My lord, here I'm putting to challenge the judgment of the learned single judge in the judgment dated 22/8/2023, my lord. Yeah, I've prepared a small list of dates. my lord.
Yes.
This is the third round of litigation, my lord. So, my lord, to brief facts, my lord. It's in the list of judges that I mentioned, my lord.
Yes.
Yes, my lord. This 21/7/2019, my lord. NIT was invited, my lord, by the Executive Engineer Rungong Division for construction of a road, my lord.
Yes.
And 17/2/2020, my lord. Bid of the petitioner firm, man. It was recommended for approval of work, man. After the evaluation of the bids, man. It was recommended. Man. And on the same date, my lord, the MLA, concerned MLA of the area, my lord, sends a UO note proposing for a retender, man. On pursuant to this, my lord, UO note of the MLA, my lord, on 4/3/2020, my lord, it was endorsed to the chief engineer, my lord, SIDP, my lord, who had no role, my lord. So he was asked to re-evaluate. So chief engineer SIDP, my lord, re-evaluated the bid and recommended for award of work to the petitioner firm after the completion of certain formalities, my lord. That was done. Then on 23/2020, my lord, file was resubmitted for approval, my lord. Approval for award of work to the petitioner firm, my lord.
What is the nature of work?
My lord.
What is the nature of work?
Construction of road, my lord.
Construction of
Road, my lord.
road from?
Is construction of a road from Rungong ADC headquarters to connect Kaing EAC headquarters. This is a phase was, my lord. Phase 1 of the project for 23 kilometers, my lord.
Yes.
Yes, my lord. And on 23/2020, after that second re-evaluation, my lord, it was again submitted for approval of for award of work to the petitioner, my lord. Then the MLA of the area, my lord, again writes a UO note, my lord, 12/5/2020, recommending a award of work to one particular firm, man. He evaluates, my lord. He comes up with some observations, and then he recommends for award of work to another firm, my lord, who were not found eligible, man. Then on subsequent to that second UO note, my lord, on 13/5/2020, my lord, bid work of the petitioner firm was again directed to be re-examined, my lord, in terms of the representation of the MLA, my lord. On 12/7/2020, my lord, the chief engineer SIDP, my lord, re-evaluates the bid, and in consonance with the finding of the MLA, my lord, the chief engineer finds that the bid of one MS Tanor Engineering, my lord, whom the MLA had recommended, is the most responsive, my lord. But it was not decided, and on 28/8/2020, my lord, retender was directed. Direction for retender was given to the chief engineer Central Zone B, my lord. This work is pertaining to Central Zone B, my lord. So that order I had put to challenge, my lord, by filing WPC 245 of 2020, my lord. The direction for the retender, my lord.
Yes.
On 22/2/2022, my lord, that WPC 245, my lord, it was disposed, my lord. And by the direction for the retender was set aside. And this honorable court direct for re-evaluation of the bid of the petitioner firm, man. Because as per the SBD, man, the employer has to evaluate the bid, open and evaluate the bid, man. And the employer is the chief engineer, my lord, Central Zone B, my lord. But the court came to the finding that there were certain officers who had evaluated the bid along with the chief engineer, directed for re-evaluation. Of course, my lord, that order we had not put to challenge, my lord, because it was no one's case for re-evaluation of the bid of the petitioner. But since there is a provision, my lord, in the SBD itself, that before finalizing, after the opening the bid, if there is certain necessity, my lord, then in retain some clarification would be sought from the bidders. No. So after the direction of this honorable court, my lord, on 31/5/2022, bid of the petitioner was found to be non-responsive by the chief engineer Central Zone B, and in same terms which was earlier recommended by the MLA, my lord, in the same conditions. And after that, my lord, on 14/7/2022, I filed the WPC 238 of 2022 and 22/8/2023, my lord. The petition has been dismissed, my lord. Now, my lord, if you lordship would come to page 50, my lord, of the appeal, my lord.
Page
50, my lord.
yes.
Yes, ma'am. Page 50 is, my lord, I have two enlistment, my lord. This page 50 is under the government of Arunachal Pradesh, my lord.
Yes.
Yes, my lord. Here I am class 1, my lord. And for class 1, my lord, my bid capacity is up to 30 crores, my lord. This page 50, my lord. And next page, my lord, page 51, my lord. This is my enlistment under the BRO, my lord. SS class, my lord. If you lordship will see, my lord, serial number 2, my lord. Enlistment of your firm as class SS contractor and BRO for tendering limit up to no limit, my lord. As per this second, my lord, enlistment under the SS class in BRO, I have no limit, my lord. Basically, it is infinite, my lord. I can bid for any work, my lord. Now, this is a work, my lord, which is above 30 crores, my lord. That IFB is at page 55. Page 55, my lord. This is 39 crores, 39 crores 10 lakhs, my lord. Page 55, my lord. And next,
55, yes.
yes, 55.
3910 lakh.
3910 lakh. So since this is above 30 crores, my lord, I submitted my bid under the SS class. Because class 1 of the state, my lord, there I am only eligible to bid up to 30 crores. Here, so I bid as a SS class contractor in the BRO. I have narrated the facts, my lord. Now, if your lordship would come to page 91, my lord. This is the order of 31/5/2022 that was put to challenge, my lord, in the second repetition, my lord.
Yes.
Page 91, my lord. Annexure 9.
Yes.
This order, the technical bid submitted by Messrs. So and so, Rungong for the work so and so, as per NIT number so and so, has been re-evaluated as per Honorable High Court judgment dated 22/2/2022 in WPC in so and so, Messrs. So and so, so and so. The technical bid of Messrs. SN Agency has been found to be non-responsive as the firm has not fulfilled the requirements under clause 4.5.4, clause 4.5.9 and clause 4.5.10 under section 1 of the SBD. These are the clauses under which my bid was rejected, second time. And These are exactly the grounds that was put forward by the MLA. man. Now I'll take your lordship to clause 4.5.4.
This 4.5.4,
my lord.
yes,
It talks about, my lord, the key technical personnel, my lord.
there's supposed to be 3 and you had 2.
Yes, two. So my basic ground here, my lord, because here there is a condition also that during the contract period, if there is the technical persons are lacking, man, then some fine would be imposed, man. So basically, what I have urged there is that, meaning thereby that 3 is not an essential numbers of key technical personnel, because the SBD itself says during the contract period, if there are the technical persons are not available, certain amount can be imposed as fine. That is there. And clause 4.5.9, man, it talks about my bid capacity, man.
No, let me understand
Man.
your argument. I'm giving a horrible example, but it's just an example to understand your argument.
Mm.
You see, a court is constituted, let us say, there's a notification that the High Court would consist of, say, 5 judges,
Man.
correct? Now, there's one condition that there 5 judges are not there.
Man.
The second thing is that there is an appointment of 5 judges, but in a division bench, when there are 2 judges, 4 are not available, and therefore division bench is cannot be constituted.
Man.
So, absolutely abstract examples I am giving. Now, taking your condition in hand, where there is requirement of 3, you have 3 and 1 leaves in the meanwhile. So, if at the time of inspection you have 3 but 2 is found, so some fine.
Man.
Now, if you don't have 3 at the initial stage, why should they give it?
That's why, man. No, man. Otherwise, what the if your lordship would come to page 129, man.
129.
129. This is the annexure 1 of the SBD, man, referring to with reference to the clause 4.5.4.
Because that is why in the first examples I gave, there is a requirement of quorum.
Mm.
In a society, there is a quorum for holding meetings. So it says that you have these so many members, but if the quorum falls down, then the meeting is invalid. Then they say that you have the option of having a adjourned meeting held on some day, and then you hold that meeting. So therefore, that lack of quorum will not come in the way. So that is the parallel I am trying to draw.
Yes, my lord, it is there, my lord. Then one of the grounds I've also urged in my writ petition is that
Yes.
there is a visible bias towards me also. There is this decision have been arrived to on the basis of a political pressure, my lord. Because on earlier 2 occasions, my lord, the chief engineer, my lord, Central Zone B, my lord, who is the employer, the tender evaluation committee did not find anything wrong with this. Again, it was re-evaluated by the chief engineer, my lord, SIDP, my lord, after the representation of the MLA, my lord, the first representative. Then also it was recommended, my lord. Now, when the MLA comes up with these findings, my lord, then only it is implemented, my lord. I have in my paragraph 18 of the writ petition also, I have made a specific argument. These are due to the political purpose, but it has not been even denied by the respondent. Because on earlier 2 occasions, first, my lord will see, my lord, the tender evaluation committee is there. They say it's okay. My firm is recommended. The chief engineer, Central Zone B, who's the employer, he recommends. The chief engineer, SIDP, my lord, he also recommends, my lord. And only when there is a specific direction by the MLA, my lord, that I should be rejected on these grounds, my lord, then only these grounds were taken up, my lord. And there is no finding as such. And
Those conditions are given for the purpose of technical evaluation.
my lord,
So how can we put our own interpretation and say that the essential qualification for the for technical evaluation is not an essential condition?
my lord, take this into consideration. Earlier on 3 occasions when I was recommended, before the MLA came into picture, they were okay with this man. There was no whisper of anything, and whisper of this man.
We don't know. You see, the omission on part of the respondents to look into your deficiencies.
Man.
There are 2 ways of looking at it. Number 1, mistakes are purchased in government parlance, and this is not my words. These are the words of the Supreme Court of India. It says that at times in the government parlance, mistakes are purchased.
That is my ground, my lord. Your lordship will take
No, but
into
if it is-
consideration. But
if that's a part of technical evaluation and you did not meet the criteria, then the first, action of the respondent authorities
Hmm.
to overlook that.
no, my lord, then whether, my lord, this should come as an essential condition, this also there, my lord. Because earlier they said, my lord, it's okay. Because the work can also go on with the presence of the 2 technical
for that-
personnel also.
For that, there's a law which is put in place by the Supreme Court of India by various pronouncements, that it is for the employer to say what is the essential condition. The court can't.
Of course, my lord, that is there, my lord. It is there, my lord.
What is that SILPI?
It is of-
SILPI, when before that there is,
yes,
there's
yes,
NG constructions.
my lord.
So how can we say when the employer wants that this is an essential condition? What parameters do we have to assess? This was not an essential condition.
Of course, man. There is no quarrel with that proposition, of course, man. But my lord will hear me out, my lord will decide on this, man.
No, I'm hearing you because of the fact that you have an IA for the interim leave.
Yes,
You are
my lord.
not
There,
proposing to-
now, my lord, I'm in a case 22 situation, my lord. Now, during this pendency, my lord, they have floated the new NIT, man. The opening is scheduled for tomorrow, man. Now, if situation is that I cannot even participate because this is pending, my lord. If I participate there, my lord, then it would mean that I have abandoned this writ appeal.
No,
It is there, my lord. So difficulty is there, my lord.
No, there's no difficulty.
I'm in such a situation
No
now.
difficulty. If there's a fresh tender who has said that
My-
the participation would vitiate your writ petition.
It would, when I have, well, there, it may come across as that if I participate again, well, I have abandoned already. I have, since I'm amenable to that new NIT, so I have no issues left. That would be interpreted. That is why I cannot even participate.
No,
there.
that will happen only when you press this writ appeal. If you wish to withdraw the writ appeal and say that you want a leave to participate in the fresh tender,
But
without prejudice to your,
I'm also pressing this as well because there, my lord, I was the most responsible bidder. So if this succeeds, my lord, then and my lord,
also,
this is
then also we may follow the Supreme Court judgment and say that when you have earned a right of claiming compensation, for which you can go to civil court.
it is there, my lord. But no, my lord, but here, my lord, basically my case is this has all been done on political
No, that is okay.
considerations
See,
and
unless
especially-
you can, this is okay, unless you can show that this is something which is inherently wrong or perverse. You see, you did not fulfill the criteria and it was allowed. Thereafter, it was found that you still do not fulfill that criteria and it was rejected. So the rejection, can it be said to be perverse? If you can show that it is perverse, you made out a case.
now, my lord, other than this, my lord, the other 2 conditions also, my lord, 4.5.9 and 4.5.10, my lord.
Yes.
Those findings are also, my lord, contrary to the records also. As well, my lord,
Well, 4.5.9, they have said that you had participated in that SS category
yes.
and that was not disclosed. Therefore, it may have reduced your financial capability.
No, my lord, that is not the ground, my lord. What they have said basically is that I have an existing commitment. So, my lord, the bid capacity is to be decided on the basis of the existing commitments because it is like a credit card that the amount that I have invested, it will be deducted from my bid capacity. That is there. But it's a very simple logic that when my tendering limit is infinite, no limit. Any amount of works that I might have, supposing that I might have the works, any amount of works, I'm infinity divided by or subtracted by anything would still remain infinite. Suppose my bid capacity is 30 crores and I'm executing a work of 15 crores, then maybe my bid capacity would be affected. But here I have no limit. So any amount of works that I do also, even then also my tendering limit would still be without any limit, as per the enlistment, And 4.5.10,
No, criteria of that central government authorities is not binding the state government authorities. The state government authority says that there is a limit.
No, my lord, they have
And the central government says it's unlimited.
unlimited.
Now, unlimited, the state government is not bound by that.
My lord,
It is assessing your financial capability.
it's,
You see, supposing I want to buy this, there is a contractor of this approved seller of this coat who supplies pencils, correct? Now, I need 5 pencils today. And this person who is having, who is the contractor, has a financial capability of only purchasing 1. So if I am ordering for 5 pencil, and he has capability of 1, will not be able to give us 5 in course of the day.
No, my lord, my participation as an SS class contractor, it has been accepted basically. They have there's no murmur about that. They have no objection to it. Only issue why they have mentioned 4.5.9 and 4.5.10 is that since I have an existing commitment and I have not disclosed that, it is going to affect my bid capacity. And 4.5.10
I'll give you
is
an
that,
example.
my lord?
My examples are horrible.
No, my lord. To my understanding,
You'll have to excuse me for that because this 10, 20 rupees, 50 rupees, these are my limits. So my examples are very small. 5 pencil. If you bid for 5 pencil and you have capacity of 1,
yes.
how can you fulfill your commitment of other 4?
But my lord, my bid capacity is without limit.
No, I understand. Nobody is
Yes.
saying, nobody is denying that. Nobody is denying that.
Yes.
But today your financial capability, despite infinity with you, is that you can only purchase your liquidity is only to allow you to purchase only 1.
My lord, that my capacity to bid or execute, it should be dependent on my enlistment and the bid capacity that has been mentioned in my enlistment order. And
In
and-
commercial parlance, it will be directly in relation to
And
your
no, my lord, from records, my lord, I'm trying to show
turnover
because
ratio.
my existing contract, my lord, existing commitment would affect my bid capacity.
You've
my
seen
lord.
yesterday's newspapers. Yesterday's news, well, that would be day before yesterday's news came in yesterday's papers. You have seen that?
Which paper, my lord?
Renowned businessman who is the owner of X has given a statement in the newspaper that the advertisements, if people are not advertising, there's a what do you call, there's a every chances of the corporate what do you call, what is that called? Corporate liquidation of that company because of lack of advertisement. You read that? No.
No.
You see, that's why I'm saying when it's in the commercial parlance, the ratio is not your unlimited capability. The ratio amounts. The ratio is dependent on the turnover ratio which you are having, the money you are having, the turnover you are having, the finances which is available to you. that would give rise to your
No,
liquidity ratio.
my lord,
If-
my
if
lord,
the liquidity ratio and the turnover ratio is a mismatch, then you can't.
no, my lord. Here, my lord,
Business.
that is not the grounded why, my lord, my turnover. That is not the issue, my lord. Here, my their bid capacity has been, my lord, they have invoked the clause 4.5.9 because there is an existing commitment. And only
Yes,
because of that
yes,
existing
that's what I'm
commitment,
saying.
yes, ma'am,
You see, you just have to twist the example which I am giving.
ma'am.
You see, you have a financial capacity of purchasing one pencil. You have already in hand a supply order to ask you to supply 5 pencil.
ma'am.
Correct. Your financial capacity is one pencil. You have an existing order of 5 pencil, and then you again bid for 2 pencils.
My lord, my lord, but this SS class and my class 1, my lord, these are two separate entities, my lord.
This nothing to do with your unlimited.
My lord.
People who are having unlimited limit is welcome in this society. But the question is that without, you see, unlimited bidding capacity is not equivalent to unlimited resources to purchase that item.
No, my lord, but of course, my lord, I get your lordship's point, my lord. But here, my lord, the ground for invoking that 4.5.9 regarding the bid capacity is that this existing commitment is under my SS class, man. That is the ground that have been urged.
That's my
my lord.
example.
Yes, ma'am.
That's my example.
But this, my lord, if your lordship will see, my lord, this on the records, my lord, affidavit filed by the respondent, my lord. This is under the class 1, my lord. Class 1 category, my lord, not the SS, my lord. Page 231, if your lordship will see, my lord. 231, my lord. And they have said, my lord, I have
You are finding any reason to interfere with this judgment?
here. Otherwise, my lord, this basic my ground, my prayer in the writ petition was also that these are issues, my lord, whether the existing commitment and my lord, number of technical key persons, my lord. It is not the case that I don't have that. Inadvertently, I put in 2, of course. That is admitted, man. I will put in 2. And this bid capacity and whether I have written any work, whether I have not disclosed any work or not. Because the records that I have been annexed by the respondent themselves, man. It shows, my lord, that the work that is going on, my lord, existing commitment from 2019, my lord, it is under the class 1 category, not under the SS category, my lord. The records itself shows, man. So, my lord,
Your financial statement is available here?
It is not here, my lord. It is not. That is not the ground, my lord. Otherwise,
No,
that
no, not
whether
that.
I have the, whether I am financially not,
No, no, you see, when there is a finding of this, of the learned single judge, you have to demonstrate that there is some perversity in it. Just
No.
because I think you have a case, it will not be a ground to interfere.
my
with
lord,
the judgment
from the
of learned
judgment,
single
learned
judge.
judgment of the learned single judge, my lord, where I have, what I'm pointing out that one, that I pointed out, whether regarding the learned single judge says that since I did not mention my existing commitment, it would affect my bid capacity. my lord.
Correct, come to,
So-
come to this page. This paragraph 10 of the judgment. There the honorable judges referred to the clause and then they have assessed available bid capacity is A into 9 into 2 minus B. So you must fulfill that criteria. If the current bid price is not available, the financial capability cannot be examined.
my lord, which,
Paragraph 10 of the judgment. The honorable single judge has referred to the
yes, my lord.
assessment of available bid capacity.
My lord.
A is maximum value of works into N, which is number of years, multiplied by 2 minus B. B is the value of at current price level.
Yes, my lord.
So if, and thereafter it says that the information of the bid is not given. And so therefore, when you have admittedly in paragraph 11, it says that admittedly the petitioner has declared nil in the information regarding ongoing commitment. Then definitely you don't have that capability. Otherwise, you would not have given nil.
No, my lord, this formula that has been mentioned, my lord. A SS bid capacity, A into N2 minus B. my lord. This also says about my existing commitment, my lord. I do not have any existing commitments regarding in the SS class, my lord. That is why I say, my lord, there is some finding error in the judgment of the learned single judge. And secondly,
No, no,
regarding
you see, you have given nil. Where is a statement that you do not have any ongoing commitment? Where is your affidavit where it says that you don't have any ongoing commitment? Question of class doesn't come here.
my lord,
Question of your class does not come here. Question of commitment is relevant.
class, my lord, class
From-
is
from
also,
your affidavit in the writ petition where you have said that this, you don't, you did not have this commitment, and it is a perverse finding.
in the writ petition, my lord,
Either writ petition or writ appeal, wherever,
my lord,
either in the writ petition or in the writ appeal, wherever you have said,
yes, my writ petition, my lord. Lordship.
wherever, any
Writ
document.
petition,
document.
It starts at page 18, my lord, writ petition, my lord. Paragraph 16, my lord.
Paragraph 16. No, don't say about no limit.
My lord.
Here you are referring to no limit, not that,
Now, I am, my lord, here I am referring to my,
that there was no commitment.
yes, my lord, referring to, my lord, I am work as well, my lord. I did not have any existing works, my lord, that I have mentioned.
Then you file an affidavit that this work of Pasighat Likam Teni Road.
My lord, there they have filed affidavit.
No, that you have said here that there was, it could not commence due to non-approval of DPR.
No.
So you say that you are not going ahead with that tender. That will make you no commitment.
My lord, here, at the time of the submission, my lord, that is one aspect. And if your lordship will come to page 231, my lord. My lord, because where I'm referring this to, my lord, when, and I showed your lordship my enlistments also, my lord. Because I have two enlistments. One is up to class 1 And class one,
No,
under
no.
the class one, my lord,
You see, we are not interested in that class SS.
my lord, class
We
SS,
are not dealing with that tender
my
for the
lord.
time being. Here, if you have disclosed your commitments, then it is okay. If you have not disclosed your commitments, then it is suppression of facts.
Yes, my lord. If your lordship will come to page
231.
231, my lord. This is, this is the counter affidavit by the state, my lord. Asian agency is the works, same work, my lord, which they say they have not disclosed as the SS class, my lord. Down below, your lordship will see, my lord, class one contractor RNV, PWD, Government of Arunachal Pradesh, my lord. This is the submission of the performance guarantee, my lord, by the Asian agency, my lord. This is under the class one, my lord. That is where, because the learned single judge, my lord, relying on the submissions of the learned senior government advocate, my lord. Because it's the case of the state is also there at paragraph 8 of the
Where
judgment,
is this 23.6?
23.6.
You have said nil.
Yes, existing commitment, yes.
You have said nil.
Yes, my lord, existing commitment. my lord. Because, my lord, if you lordship will come to page 241 of the judgment, my lord, paragraph 8, my lord. Here also the
No.
arguments advanced by the learned senior government was that SS class category, I have one existing work, my lord. That if your lordship would come to,
No, I'm really not asking you about your nature of your registration. What I'm asking you is that supposing you have 100 rupees with you,
my lord,
now how much commitments you have already made?
my lord.
You see, I have 100 rupees with me. Today, I assure my spouse that, okay, I'll take you to a movie tomorrow. 50 rupees gone. I assure my children for day after tomorrow that, yes, I take you to a movie. Again, 50 rupees gone. On third day, I call you to my home for a cup of tea. And then my budget is 50 rupees for you. So when I have got 100 rupees and I have an expenditure of 1, 2, and 3, 150 rupees. Now the question is that the government is merely asking you, the tendering authority is asking you, what is your commitment?
The commitment
if you-
as a, my lord, SS class, my lord. That is, my lord, if your lordship will come to paragraph,
You are again coming to SS class. I'm not concerned with your SS class. I've given you examples.
Right.
You have 100 rupees in your pocket. Now let us give a separate example. You see, you have a credit card with unlimited withdrawal facility. Unlimited. But today from our High Court building, you have to go to say a place 5 kilometers away, auto fare is 100 rupees. Correct? Your credit card unlimited withdrawal facility. But you are going someplace where the auto fare is 100 rupees and you have 50 rupees in your pocket. Now, do you think that a auto driver will take you on credit for 50 rupees and say that, okay, you go to your ATM, if you can withdraw money, then you pay to me. See, you have unlimited withdrawal capacity in your, you will show him your credit card that look, gold platinum category credit card. I can withdraw 10 crore from that card. But the auto is interested only in 100 rupees. And you have 50 rupees in your pocket.
that example, my lord.
So
My
you
lord,
see,
here,
that's
no,
what
my
they are
lord.
asking, that you have a commitment of how much? You have a financial capability of how much? You have a commitment of how much? And whether you can participate here. That is the only question. So your class,
My lord,
your
no,
this
class is, my
platinum and
lord,
gold
important here
credit
because,
card.
my lord, I have participated here as a SS class, my lord. At that time, my lord, they are not to consider my class one category, my lord.
No, because I can't simplify the, what you call, I cannot give a more simplified example.
Because, my lord, here I am participating as a SS class, my lord. So, what is my tendering limit, my lord? That
Correct.
is,
You are an
that,
SS class.
my lord.
You are an SS class, but you have 50 rupees in your pocket right now. You have to go to a place where the auto fare is 100 rupees. Now tell me, how do you, what do you call, how do you explain that?
Well, because
You see,
when I, my
you
lord,
can't go to an auto driver and say that, look, In SS category, I have given my tender. After 1 month, I'll complete the work, I'll get the 100% my money, and then I'll pay you 50 rupees later. You have a SS class registration, but you need to purchase 1 ton of iron.
No, my
So
lord,
that doesn't entitle you, that SS class registration does not entitle you, just like your gold class or platinum class or diamond class credit card, does not entitle you to that purchase unless you withdraw money from the ATM and then give it to that that owner of the shop when you are purchasing something, or you transfer it online.
no, my lord, here why I'm harping on the SS class, because here they are to consider whether I have misled, I have suppressed anything on the basis of my enlistment, my lord. On the basis of my enlistment as an SS class, whether I have any existing commitment or not. That is what they had to assess, my lord. They did not do that. The
You see,
submission of the learned single
judge.
judge,
You show me one line where you said that you have not had any commitment. You have shown me page 60, para 16 is not there.
man.
You are referring to a
Paragraph-
class. I am not interested in that class. We are a classless society right now.
but they have divided the contractors into classes, my lord.
No, I don't know, but still we are a classless society. You get, you see, by virtue of the reservation, you get an additional advantage. But still we are a classless society.
My lord, regarding the existing
You-
commitments,
you
paragraph 16, it is there, my lord. That existing commitments only based on state, because they have said, my lord, it is not because I do not have the financial capacity or not, that is not the ground. They're saying that since as an SS class, I have an existing commitment, I have suppressed that fact, and because of that, it is going to affect my tendering limit, my lord. But it is not the case, man. Here is a
also-
case where
we
that
also
work
think
is
so.
under the class 1 category, my lord.
We
The
also think
submission
so.
of the PG itself, my lord, shows, my lord.
No.
And that is, my lord, one plea also that I have taken is that as per clause 23.4, man, if after the bid evaluation, my lord, opening of the bid, my lord, if it is at page 122, my lord, if they could have given me
Can I
the
give you
opportunity,
Another worse example. Can I give you another worse example?
because,
I'll
yeah,
tell
my
you,
lord,
because this is something which happens in my court daily.
my lord,
Learned lawyer will come and say that, Lordship, I have a commitment in court number so and so. I have a matter there. So please adjourn the matter for time being because I am in that court. After that, the junior will come and say that, Lordship, that argument is still continuing and therefore this matter may be adjourned for the day. So you see, and this the civil procedure court says that having a case in another court is not a ground for adjournment under Order 17 Rule 1. So therefore, if you have more commitments than you can handle, even as a lawyer, you are bound to omit some court and give priority to the one where you have more better interest.
no, my lord, the judge examples there, my lord, but
Worse was, I know it's a worse example.
no, my lord, it is there. But my lord, what only I'm urging is that when I have submitted as a, because the class is also important, my lord, and whether I have the
No,
financial,
I'm sorry. We'll come
whether
to that, participate.
financial capability or not, my lord, it could have been clarified by
No,
23.4 of
we are not
the,
impressed. With that class, we are not impressed. I'm sorry. We'll have to dismiss your appeal. But
because,
no, Mr. D. Soki done it. Yes, unless you admit what he's saying.
Lordship has already observed above that I have nothing to say, Lordship. I must not, Lordship.
because otherwise also his submission is also that my existing commitment is as a SS class, my lord. That is
No,
what
it's okay.
has always been
Class,
ours then.
we're not impressed. But Mr. D. Soki, then counsel for the appellant. as well as Mr. S. Tapin Ranjan, Senior Government Advocate. Your designation is Senior Government
Yes,
Advocate. Appearing for all the respondents?
All respondents.
For the respondents. Agreed by the judgment and order dated 22/8/2022, passed by the learned single judge in WPC 238 of 2022. This intra-court appeal has been preferred by the petitioner. Next part. In the writ petition, the petitioner, who is a class 1 category contractor under the PWD.
My lord, class SS, my lord.
No, in PWD, you are
PWD class 1, my lord.
class 1, class 1. And SS category contractor with,
No limit, my lord.
no, with whom?
My lord,
BRO.
BRO, my lord.
With Border Road Organization. And whose tender was rejected by the respondent authorities on the ground during technical evaluation, has prayed for setting aside the order dated 31/5/2022, by which the technical bid of the petitioner of the appellant, so it will not be petitioner, it will be appellant. Appellant was found non-responsive due to non-fulfillment of clauses 4.5.4, 4.5.9, and 4.5.10 under section 1, numerical 1 of the standard bidding document within bracket SBD for short bracket close. Full stop. The appellant has also paid for a direction to the respondent authorities to give him an opportunity to clarify or modify his technical bids as provided under clause 23.4 within bracket small Roman 2 bracket close of the invitation for bids within bracket IFB for short bracket closed, and for a direction to the respondent authorities to award the work order to the appellant in respect of the work mentioned in IFB dated 21/7/2019. Next one, the learned single judge. On evaluation of the materials available on record. Arrived at a finding that to the effect that in terms of clause 4.5.4, instead of having 3 minimum key personnel for the project, the appellant had only to such personnel. And accordingly, it was held that the shortfall in the in clause under proviso to annexure 1, will only mean that the shortfall refers to the subsistence of contract period and not a shortfall of personnel at the time of initial tender process. First of all, in connection with clause 4.5.9 of the ITB, it was held that that the appellant had declared nil on the information regarding ongoing commitments, which was not found to be correct. Therefore, it was held that that there was no compulsion for the respondent authorities to seek clarification before coming to a finding that the tender of a particular tenderer was not responsive. And in the said context, the learned single judge arrived at a finding that the irrelevant clauses mentioned in the impugn order dated 31/5/2022, being a part of the technical bid, cannot be considered to be ancillary or subsidiary with the main object to be achieved in the tender, which has a value of work amounting to rupees 39.10 crore. And accordingly, it was opined that the case of ORYX Fisheries Private Limited versus Union of India and others, 2010 13 SCC 427. But no application to this said case. Accordingly, the writ petition was dismissed. Next one. The learned counsel for the appellant has submitted that has referred to the statements made in paragraph 16 of the writ petition. To project that the existing commitment in respect of a work, inverted commas, care of CO, Pasighat-Ledum, LEDUM -1080 Road, within bracket 20.00 km dash 40 km bracket closed and invert comma closed was because at the time of submitting the present tender of the bid in question, the execution of the said work had not commenced because of non-approval of the DPR. It is also submitted that with the border of the organization, the petitioner is a SS class contractor which had no tendering limit, and therefore the petitioner had the capability of tendering with no upper limit. Hence, committee submitted that as the present tender was for sum of rupees 39.10 crore. The non-mentioning of the existing commitments would not affect his bid capacity, the applicant's bid capacity. Hence, it was submitted that the appellant had not submitted any misleading or false declaration or suppressed any information of the works in hand. And therefore, the bid of the petitioner, the appellant, could not have been rejected under clause 4.5.9 and 4.5.10 of the SBD. Next paragraph. It was also submitted that the bids of the submitted by the petitioner was evaluated on 3 occasions. First of all, on the first occasion, the bid of the appellant was found responsive, and on a complaint made by second is by complaint by
Malad, by
appellant.
second time it was also evaluated by the chief engineer SIDP, man.
Okay. So, on the second occasion, on objections raised by the chief engineer
SIDP, man.
within bracket SIDP
DP.
bracket closed, the bid of the petitioner was re-evaluated and he was once again found responsive, and his bid was found responsive. However, on the third occasion, a complaint was made by the local MLA, and which was on the same ground on which the chief engineer within bracket SIDP bracket close had raised objections, and this time with a mala fide intention and on being influenced by the local MLA, the authorities on this occasion found the bid of the appellant as non-responsive. Accordingly, it is submitted that it was only because of the political interference that the respondent authorities had changed their view. Therefore, it's submitted that the appellant had merit in the writ petition and therefore prays for allowing the writ petition by interfering with the judgment and order passed by the learned single judge. Anything I've left out?
Well, basically, man, but that clause 23.4 is also there, man, where and where the after the evaluation, bid opening and evaluation, man, the authorities can seek clarification from me. Man.
Yes, I have referred to that. In my, in my reference made earlier, so let me wait. Next one. The next para per contract, comma, the learned additional senior government, sorry, senior government advocate has support the impugned judgment and order passed by the learned single judge. Next para. The only point of consideration which arises for decision in this appeal is as to whether the finding of the learned single judge on in the matter of upholding the rejection of the bid of the petitioner on under the for non-fulfillment of requirement of clauses 4.5.4, 4.5.9, and 4.5.10 was sustainable, or whether it requires interference from this in this intra-court appeal. Question mark. Next one. It is not in dispute that the appellant had provided particulars of 2 numbers of key technical personnel in its bid against the requirement of 3 numbers of key technical personnel. And moreover, the appellant was accused of suppressing one ongoing work as SS class contractor with the BRO. And that the submission of the learned counsel for the appellant is that he could that the respondent authorities ought to have given him an opportunity of clarifying or rectifying his bid, for which there are provisions under clause 23.4. In the 23.4 is in ITB or SBD?
Malad?
23.4 is in IBD or SBD?
ITB, Malad, is a
In
part of the
ITB,
SBT,
okay,
Malad.
in ITP.
Yeah, sorry to interrupt, Malad. Here also the finding is of the learned single judge is that I have an ongoing commitment as an SS class, Malad.
Yes,
That is.
that's true. That is true.
No, Malad. That's why, Malad, I was showing you, Lordship, the PG that I have submitted under page 231, Malad. It is under the class 1 of the state, Malad. State PWD, Malad. Page 231 that I in 230 and 231, Malad. If your lordship will see down below, my lord. That is why, my lord, the finding, my lord, is contrary to the records, my lord. Down below, if your lordship would see, my lord, it is a class 1 contractor, man. RNB, man, Government of Arunachal Pradesh. This is not by the SS class, my lord. Whereas the finding of the learned single judge is that it is under the SS class, man. 231 down below, my lord. This is a performance guarantee submission, man. This PG have been submitted by the class 1 contractor, but not the SS category. Two 31. And this is the 230 and 231. This is the records of the affidavit filed by the state.
Okay. In this said context, the learned counsel for the appellant has referred to the copy of agreement within bracket annexure E bracket closed to the affidavit in opposition filed by the respondent numbers 2, 3, and 4 in the writ petition. Project that the said contract work was not in respect of SS class, but it was a contract with the state government, wherein the petitioner had projected himself to the class 1 contractor. That fact that the petitioner was had not submitted tender in the SS category, but had submitted tender in the class 1 category. Would have no impact on the finding reported by the net single judge. Because the essential facts remains unaltered to the effect that the appellant had not disclosed what they said ongoing commitment in his bid submitted in this in connection with the present tender.
Because as per the SBD, my lord, I am only to disclose the works that I have, my lord, the applicants, my lord, not the works that is in another category, my lord. Yes, since the applicant was in SS category, I was not required to disclose, my lord, that under the class 1 category.
Therefore, the facts remains unaltered. With the financial capability of the petitioner not have been assessed for non-disclosure of the existing commitments. Therefore, the finding of the learned single judge on the non-disclosure of the existing commitments do not require the interference from this in this inter-court appeal. Next one. Insofar as the non-disclosure of no, sorry, the lack of key personnel. The courts of the considered opinion that the learned single judge had correctly, they had rightly appreciated the fact that the key personnel the requirement of key personnel in the as per the tender where was 3, whereas the applicant had admittedly provided particulars of only 2 key personnel, and therefore the notwithstanding that the tender conditions entitle the respondent authorities to deduct money per month from the tenderer on pro rata basis. But said clause does not envisage shortfall at the time of initial tender process. Full stop. If on this ground also, the finding returned by the learned single judge does not warrant any interference. Next paragraph. Insofar as the non-invocation of clause 23.4 within bracket Roman 2 of the ITB, the view in the considered opinion of the court, the view taken by the learned single judge that there was no compulsion for the respondent authorities to seek clarification from the applicant before coming to a finding that his tender was not responsive. Therefore, although there is a provision in the tender document which permits the tendering authority to seek a particular clarification, because the said clause, existence of such clause would not mean that in every case the respondent authorities are bound to seek clarification before declaring a particular tender as non-responsive. In view of the court does not find that the learned single judge had the judgment of, the judgment and order passed by the single judge, which is included in this present appeal, is vitiated by any perversity. Or that the reasoning is, and that the reasoning cannot be held to be hit by the principles of Wednesbury principles of reasonableness. According to this reputation, filth and the same is, the rate appeal filth and the same is dismissed. That's all parties are left to bear their own cost. There will be another order in this IA. In your order passed in so this IA stands closed.
Oh, our lordship.
It's a jail appeal
Your lordship,
for the first time.
yes, your lordship, lordship,
We'll have to appoint a Mike Curie.
yes. Also, legal aid council, your lord, since this is from the legal aid council, the list is with the registry, your lordship.
Ah.
Also, your lordship, this item number 4,
You just suggest whose name we can appoint.
pardon, your lordship.
Can you suggest a name whom we can appoint as a Mike
the-
Curie?
The registry have the list of panels of advocate for amicus as well as for the legal aid, your lordship.
Okay. So we'll have to just say that they will appoint someone from the list.
Yes,
Only that much.
yes.
Jail appeal. RPC. RPC. You will present report. Just pass it here. We have the 374. 2. Read with 380. 3 CRPC. The appellant who is in jail has provided this appeal under section 374, read with 1 CRPC, 383 CRPC against the judgment and order of conviction dated 17/11/2021 passed by the they call district session judge or special judge, also matter. Special judge. Learned special judge. Session judge. West Kamai District, Bombila. Where is the appellant was convicted under section 376. IPC read with. No, section 376 within bracket 2, within bracket small f IPC. Read with section 6 of the POXO Act. Just one minute. Yeah. वो charger है 376 2 है. I think it will be same. Oh, no, not only 376. 376, the IPC read with section 6 of the POXO Act. And resultantly, he was sentenced, the applicant was sentenced to serve rigorous imprisonment for 20 years for under section 6 of the POXO Act. I think this is 76, 376 sentenced. Okay. That is the response of the POXO Act. Next, if it is a bit hearing call for the records. Okay. Next, as the offense involves offense under section 376 as well as section 3/5 and 6 of the POCSO Act. The registry shall implead the
One is solely based on last seen theory. No motive, no evidence, no weapon of offense, the clothing, because the medical report says,
Your Lordship, may I point out, Your Lordship, colleague judge was the session judge at that time, who recorded the position statement of 7 PWs, prosecution witness.
that this
No,
cannot
no,
be a bar,
That won't be a ground for
that
accusal.
cannot be a bar.
Okay,
The
yes,
judgment was
I'm
rendered by-
only
The,
pointing.
the honorable judge, the session judge was evaluated the evidence and
Evidence recorded.
passed the judgment. I think only he can be
Yes, yes,
recused.
Absolutely.
He can recuse himself.
absolutely. Your Lordship may kindly have the paper book.
Yes.
To take your Lordship through the medical report first. At page 20.
My brother has a reservation, so therefore it will be before any other bench without.
Otherwise, my lord, my
No,
humble
no,
understanding of that cannot,
No,
that is not a bar.
that. It's just a call of the conscience, number
Right.
one. Number two is that my brother says that the charges were also framed by him.
Yes.
It is a part of decision-making process. That's right.
In-
Is this matter for any other bench without one of us? You can take it.
Problem.
That's a call of conscience.
Otherwise, the judgment was rendered by.
No, that's okay, but that was the initial view, but one.
Okay.
May I plead, Your Lordship? May I plead, my lord? In this matter, my lord, the conviction was based on confessional statement, that is one. Another is that
Yes.
yes, my lord. My lord, if we start
No,
from the
just
paper book.
Before you begin, we'll take a small 2-minute break and come back. We'll take a 2-minute break and come back.
Okay.
Just. Take a 2-minute break and come back.
Accused is not mentioned. Third, there is no eyewitness. Only the conviction was based on the circumstantial evidence. So I'll just may take to the paper book, start from the FIR, alert. FIR, the complaint is in page 1. Page 1, may I read, Your Lordships. I am to inform you that today on 12/11/2016 at about 1000 hours, while I was at my home, one Srimati Rena Sunar, wife of such and such, two other ladies of Kauji Pathar village came to my house and told me that they had noticed one dead body lying in the roadside bushes between the Kauji Pathar village and Bisa Agro Tea Estate. On getting the information, I, along with people residing nearly, we went to the spot and found one dead body of unidentified lady lying in the midst of bushes in decomposed condition, which is suspectedly murdered by Sonar, this unknown person. Here is Sonar, whereas the accused name is Padma Sonowal, not the Sonar and unknown. Accordingly, the matter has been informed to the manager of Bisa Agro Tea Estate, and the FIR is being lodged before the police station for the initiation of legal action and investigation, please. And this complaint was filed by Jitin Boomji, one of the witness in this. Total 14 prosecution witness was examined. Well, on the basis of this FIR method, investigation was done. And as per the medical report also, it says they're not able to ascertain how the victim died. Medical report also says that they're not able to ascertain. Malajus, I will take to the list of the prosecution evidence and the cross-examination. Out of 14, only the IO and 2 or 3 witnesses, rest they turn hostile. I'll just take to the prosecution witnesses. And my other submission will be 164 CRPC was not properly followed. That will be also my submission here, Malad. So, Malad, I'll just take to the first prosecution witness. PWD 1 is in page 58. Page 58, Malad.
Yes.
Yes, may I read, Malad? I know the accused person standing on the dock by name Manoj Sonowal. I forgot exact date of the incident, but in the month of November 2016, I was informed by some woman, he is not a direct eyewitness, some woman about lying of one dead body in the jungle of Bisa Tea Estate, and accordingly I visited the same. Having heard the same, I first informed the matter to the general manager of Tea Estate and then OCPS Burdumsa. The OCPS Burdumsa arrived at Tea Estate, and accordingly, we have shown him the place where that body was lying in decomposed state. I have also seen the dead body which was in decomposed state with maggots. None of us could have identified the dead body. I have also seen one sleeper lying near the dead body. The exhibit such and such. And the mallet in the cross mallet. In exhibit mallet, exhibit 1 is a FIR lodged by me, and exhibit 1A is my signature thereon. Exhibit 2A is my signature on the seizure memo. Exhibit 3A is my signature on the inquest report. Exhibit 1 shown to be today in the court are 17 numbers of photographs of place of occurrence, dead body and gray color slipper which I have seen on the day of inquest. Cross, my lord. FIR was not drafted by me. In fact, the complainant says the FIR was not drafted by me, by some police personnel. It is a fact that I have not seen the person cameraman who flashed a photograph of the dead body. Today only I have seen the photograph shown to me today for the first time. The slipper which I have seen at the place of occurrence is not available before me today in the court. So this is the in the cross, my lord. And my lord, prosecution witness number 2, also he is one of the seizure witness. He says that I am without my consent, the signature was put. Then in the seizure list, the PW2 is a person who signed in the seizure list, my lord. So there is a page 60, my lord. I will just take to page 60. It's a PWD2. Yes, Mr. May I read, my lord? The deposition of Sip Soma Mara, age about 37 years, taken on oath, solemn affirmation under the provisions of X and such. May I just read to the main the facts, my lord. I know the accused person standing on the dock. His name is Manoj Sonowal. Having heard about the incident, when I visited the PO, I saw the dead body lying on the ground. Police arrived after some time. Though we were asked to identify the dead body, we failed to do so. The doctors and the police arrived on the next day also, conducted post-mortem examination. Accordingly, the dead body was cremated thereafter. P Exhibit 2B is my signature on the seizure memo. P Exhibit 3B is my signature on the inquest report. P Exhibit 4A is also my signature on the seizure memo. Now in the cross, he says that, in fact, may I read, my lord? In fact, that I have put my signature on the paper exhibit as stated above without knowing the content thereof. That's how the PWT 2 is, my lord, statement, my lord. And then
You see, that's not fatal.
yes,
In my understanding. Long back, I took a car loan. And the bank made me sign hundreds of documents. I signed each and every piece of document without knowing what the contents were.
yes, I just want to contradict. I mean,
No, that's okay.
that's right.
But you see how it is fatal. The seizure witness does not say that no seizure was made in his presence.
Yes,
Maybe he does not know English and or the language in which the seizure memo was made. And he says that I don't know the contents.
yes, sir.
I'm also putting myself there and I'm
Apply,
telling
apply.
you, when I took a car loan long back,
Mhm.
then I had signed so many documents, I won't remember what I
Without
signed.
knowing all what is contained in the agreement.
This any app in the mobile you download, you will say I agree to the agreement. What is the agreement? I have never read.
Yes, that's
So before non-reading of the agreement, can it be fatal? Or non-reading of a document where you have signed, is it fatal? Unless he contradicts his statement that he saw the seizure. That's not there. So it may
Yes,
not be so fatal.
and then my lord, PWD3 ballot. PWD3 also my lord, in page 62. He also not a direct eyewitness. He also says that I was also informed by others, my lord. So may I read in page 62. Page 62, my lord, PW3, my lord, may I read? I know the accused person standing on the dock at the Monojit as he hailed from our nearby village. I forgot exact date and month of the incident, but his incident so far I remember took place 9 months before. I, on being informed by one C. Jiten Bumji, visited the PO and seen the dead body lying inside the jungle of Karem Bayside Tea Estate. Police recorded my statement. P Exhibit 4B is my signature on the seizure memo. Well, in the course, I put my signature on the paper exhibit as stated without knowing the content. They're only being asked by the police. So this is how the seizure memo, the witness also says, my lord, in the PW3, my lord. And other important is that, my lord, the last seen theory also not applied here. I will just take to the prosecution witness 4 is in page 64. Is one of the prime witness. In fact, the law session court has relied on his statement. Page 64, married. I know the accused person standing on the dock as a Manojit Sonowal, accused who hails from my village. My statement in the case was also recorded by the magistrate. I forgot the date and month, but one evening, maybe in the month of November, I saw the deceased such and such standing, or deceased such Ratne Mora, the victim, standing under the bamboo groves. On being asked by the accused, Manoj Sonowal took the deceased to the house of one Srimati Radhika Bomji, but she refused to allow the deceased stay in her house. The accused who asked me to took the deceased to the house of Radhika Bomji also told me that he will come to the house of Radhika Bomji after closing his shop. On being refused by Srimati Radhika Bomji, when I informed the same to the accused, he again asked me to take the deceased to take her to the government primary school, Kauji, Pathar, which I did accordingly. After leaving the deceased at the school, when come back toward my home, met the accused on the way, who was proceeding toward the school where the girl was waiting for him. The deceased at that time, he was in the white colored dress. After 4 to 5 days, I heard about the death of deceased girl. Exhibit P5A is my signature in the seizure memo. I put my signature on the paper as I was asked to call Radhika Bomji. Exhibit 6A is my signature on the statement recorded by the magistrate. In the cross, my lord. At the same time, at the time of recording my statement by magistrate, I was also taken to the court of magistrate of police. It is true that I was asked by the accused about 5 p.m. The timing is very important, my lord. Here he says that 5 p.m. But then as per the statement of the IUO, it says 7:30 a.m. 7:30. So there is a differences of timing also, my lord. 5 p.m. in the month of November. It is also the fact that I, alone with the deceased, while I took her to school, I took the deceased to the school at the dusk hour. I was not made to know why the accused asked me to take the deceased to the house of Radhika Bomji and the school. I have no idea who killed the deceased. He also not direct eyewitness. He also said that who killed the deceased. I don't know what kind of relationship the deceased had with the accused. It is also a fact that I have not seen the accused and deceased together in the evening. So the last seen theory also doesn't apply. In fact, the learned session court has relied on heavily on this PW4. I took the deceased to the house of Radhika Bomji on being shown by the accused. It is also
this judicial magistrate was not examined.
Not examined.
Bodum sir, he was not examined.
Not examined.
I took, yes, the magistrate will also not examine, my lord. I took the deceased to the house of Radhika Bomji on being shown by the accused. It's also a fact that while taking the deceased to the house of Radhika Bomji, I have no conversation with her. So this is the main witness in this prosecution evidence in this case. But he also says that he have not seen them together. And he also says that timing is 5 p.m. But I will just take to the other prosecution witnesses IO. He also says 7:30 p.m. Now, Your Lordship, I will just take to the prosecution witness 5. Prosecution witness 5, Your Lordship, the deposition of Anthony Mora, age about 29 years, taken on oath or solemn affirmation under provision of such and such, on this 12th of November 2017. Now, may I read on oath his statement? I know the accused person standing on the dock by name as Manojit Sonowal, accused hailing from a village. I appear today on being summoned by this court. I forgot the date, month, and year of incident. one day when I was staying in the house of my uncle, I heard one unidentified.
Just
Yes, ma'am.
see. What is he, Mr. Kadu? Yes. You see, in this case, if the magistrate has not been examined, number one,
Yes.
The judicial confession goes away.
No, a non-examination of mistake is not fatal to prosecutions.
It's not-
Even IO cannot, IO may be also not examined. It's not fatal. It's not against the prosecutions.
How do you
And
prove-
there is a 164 statement.
how do you prove a judicial confession then? If the magistrate is not examined.
It's from certificate appended with confession, certified by magistrate.
But anybody who does any act must be examined to prove that. Is there any judgment or any court which says that non-examination of a magistrate recording confessional statement will not be fatal?
I I have come across one judgment, Supreme Honorable Appeals Court judgment. I have to charge it again.
The IO is PW
My lord, IO is PWD 13, my lord.
13.
Page 78.
Page 78.
I find it very difficult. See, come to page 79 of the paper.
79, yes.
Page 79. Last. After forwarding the accused to judicial custody, I have also forwarded the accused person for recording his confessional statement as part of section 164 CRPC. Now, you see those, the facts that he was given a chance for recollection, that he should be out of this police influence, the reflection time, then the correctness of the certificate. Those things are, these witnesses have not said.
Yours, Lordship, epistle.
Yes, so confessional statement is
Oh.
is exhibit 14. Now.
Confession statement was recorded when accused was
Please,
in judicial custody.
Please hear me and then respond. You see, now let us say this book is a relevant piece of evidence. Correct. And I, as a witness, say that exhibit 1 is this book. Correct. And now that means it becomes a duty of a sessions court or a high court to read the entire book and to find out. Because I'm under the impression that marking a document as exhibit and proving its contents are two different things.
Yes.
So if I am only to mark this document as an exhibit, well and good. But you see, for example, the banker's books of accounts, it may runs into hundreds and thousands of pages. So the relevant entry where the fraud has taken place, you'll have to mark that and then say entry, the offending entry where there was a fraud committed is marked as exhibit 1 by 1. This is how I'm thinking. I may be wrong, subject to correction. But therefore, I find that there's a vast contrast between marking of a document as exhibit and proving its contents. So therefore, you see, it's a case where somebody is given life imprisonment. He could have been also been awarded a punishment of death, 302. Now the question is that if you don't don't prove that particular entry in the confessional statement with regard to time of reflection, he's not under the police influence, and third, that the confession was voluntary. See, if that statement is not there, how does the ingredient of a confessional statement got proved? That is the first question. Second part is that in a 313 statement, is it not relevant aspect to accost the accused with the circumstances you look, there was a confessional statement where you were beyond police, where all the parameters of the confessional statement was maintained. Because in the statement, when you say that there is a confession statement, you said that I did not confess. And so there was a confession. Who will prove it? The author of the document. This is the second thing. The third thing is that the author of a document, who is the judicial magistrate, and he has signed it, he is not examined. Therefore, the entry itself, can it be said to have been proved in accordance with law? You see, I am giving you one more explanation. In criminal side, it is more strict, but in a civil side, let us say defamation case, you not only call for the you don't only prove the newspaper, you also call, you have a requirement to call for the manuscript. So it is the manuscript which is the original. And then the newspaper printout is merely a secondary evidence. And if the manuscript is otherwise proved, then all copies of the newspaper become evidence of, becomes an admissible document. So these are the three reasons why I'm asking this question. How is a confessional statement proved?
Here, Your Lordship, in-
IO, you see, IO being a policeman, he could not have been inside the what you call courtroom when confessional statement is recorded, because then he would be directly under influence of the confessional statement would be initiated, being recorded in presence of the police. So therefore, a police is an outsider. He could not have been there in the courtroom when the confessional statement was recorded. So how can the IO say? IO can only prove that I have sent him for confessional recording of confessional statement. Only that much and no further, because he is not privy to the recording of the confessional statement itself.
uh, at what is atmosphere this confessional statement was recorded is justifiably here in para 39 of the judgment by trial court, Monday trial court.
39.
It is just
Because it's not a case under section 32 of the Evidence Act that this person could not have been, his attendance could not have been procured within the reasons which are explained in section 32 of the Evidence Act. 39.
yes of judgment, page 18, page 107, internal page 18.
Page.
May I read this?
39.
Yes.
39 is a statement of PW8, Purojit Sonwal. Is either 8.
Here are 39.
or page 107 then.
Yes, 107, internal page 18.
One 107, yes.
May I read this?
Yes, please.
I have observed from the record of the case that the accused Monjit Sonowal was arrested by police on 14/11/2016 and produced before magistrate on 15/11/2016. And thereafter he was remanded to police custody for 7 days. On 22/11/2016, the accused was again produced before magistrate by the IO with a prayer for recording confessional statement of the accused as provided under 164 of CRPC. On 22/11/2016, the magistrate has remanded the accused to judicial custody, and after staying for 8 days in judicial custody, the confession statement of the accused was recorded by magistrate on 30/11/2016. In view of the same, it is observed that the accused was provided sufficient time for reflections before recording the confessional statement, and there was no chance for atrocity by the police before recording of confessional statement of the accused, as he was produced from judicial custody before confessional statement was recorded.
But where is that evidence to that effect?
Even LCR was not here. Today morning I was looking for LCR.
Which I should be here. It's here. No, just give it to him. No, give it to Mr. Kadu. Don't give it. Give it.
Once
Your Lordship, next that maybe even for so that I can finish the detail of LCR.
No, you see, what I'm trying to ask you is that you can go through it, we'll give you time. But you see, what I'm trying to ask you is that in a sessions case, if I've understood it correctly, the principle is that the evidence tendered must point out a strict evidence, proof beyond reasonable doubt.
Yes,
That is
basically.
Now, the circumstances that in a confessional statement, there are 2 or 3 requirements. Number one, he should be free from police influence. For that, there is a statement recorded that he was given time for reflection and there is no policeman in the courtroom when his evidence is recorded. That is a part of a certificate. Now that certificate is required to be exhibited if I am thinking correctly. It will be marked as an exhibit, or otherwise if a magistrate himself comes and deposes, then there's no requirement of marking that particular piece of certificate as an evidence. Because if the magistrate is there and is present for cross-examination. That is one part. But if IO is doing it, he'll have to satisfy the court that these precautions were there. This is one part. Second is that can a certificate be proved by someone else without exhibiting the signature? Because then what would happen is that there can be any inquiry and then the report of inquiry or report is placed before the court. It becomes admissible just because it has been marked as an exhibit. The point I'm trying to ask you is that is it not required that contents of the not only the contents of the report be proved or certificate be, because then you see post-mortem report. Why you need an IO to come to the court and then the doctor to come into court and say that there's a document. IO will come and say that, well, this is the post-mortem report certified by the competent doctor, and I'm proving it. The other material exhibits, which are signed by witnesses, whom you call seizure witnesses, why are they required? You can just have it recorded, and then the IO will come and say that, well, I am the person who has seized it in presence of ABC. Their signatures are A, B, and C. So A1, A, B, and AC are the signatures, and therefore that is proved. So why there is a twin requirement or an exception carved out? In a seizure witness, you need a seizure witness to come and prove it. But when it comes to the recording of the confessional statement, you don't require a magistrate to come and prove it. Why there is an exception? You are saying that this is not fatal. The query of the court is that why an exception should be carved out. That one document like postmortem report or seizure list can be proved by the person who has signed the seizure list. Why an exception that the magistrate is not required to be examined when it comes to the, or somebody must come and say that, well, this magistrate is no longer here. He could not have been procured within a reason for these reasons. I am acquainted with his signature and therefore I prove it. It's
Yes,
still a mode of
general
still a mode of proof. Somebody who is acquainted with the signature may prove it. IO does not come and say that the magistrate's signature is so and so, and I know it. This is the court query. You can go through the records and address us. No problem, no issue with that.
As per my understanding, official witnesses, their magistrate is an official witness, so their document, if not challenged, he need not be summoned as a witness.
No, there is an exception carved out. So the exemption is not for all. The exemption in the CRTC is only for certain people. President, there is a list of $293. In fact, in this chapter, It starts from part B to 84 onwards. When attendance of witness may be dispensed with and commission issued. And thereafter you will find commission to issue whom so and so party to examine witnesses written of commissions. Now, evidence of officers of the mint. Then you will find 293. Report of certain government scientific experts. And it is these offices who are exempted.
Okay. 293.
And there's also a provision I have forgotten, the president, governor, chief minister in office. But they are also, they form a part of list where there are privileges for them not to appear as court witnesses.
As per Section 80 Indian Evidence Act, as per Section 80 Indian Evidence Act,
80.
there is a presumption of document presumed by the court. Presumption has to be made by the court.
This is not an
When,
official document. No. Confessional statement 165 is not an official document.
No, it is here specifically reflected that confession by any prisoners.
No. You see, if I have understood it correctly, under the scheme of the criminal trial, what happens is that if a person, if a statement made by a person is required to be reduced under section 164 CRPC, or a dead body is required to be sent to the for postmortem, a GD entry is made to the effect that now we are sending this person for examination under 164 CRPC. You see, a magistrate does not have a duty to record confessional statements. Otherwise, in the process of law, supposing today I am asking you a question and you are offended with the question I am putting to you. Can you go to a magistrate and say that, well, we have a duty under section 164 to record a statement, and therefore, yes, I am here. Today, something happened in court, I am not satisfied, and therefore, please record my statement under 164. Can you do it? No. There must be a criminal case. You must be forwarded by a IO, and in that connection, he records an GD entry and then sends you to for recording of this statement. Then under 164, a duty is cast on the magistrate to record this statement because his action is in furtherance to a criminal prosecution, and therefore he is doing it. So just because today you are dissatisfied with the question I'm asking, you just go to a judicial magistrate and say, please record my statement under 164, because that is not an official act.
Yes, it is.
Just like an affidavit, you go to a judicial magistrate. It has happened to me, and that's why I have heard it, and that's why I'm telling you. Affidavit, you go before a judicial magistrate and say that, well, I have prepared an affidavit, please sign it. Now tell me, is a judicial magistrate bound to authenticate that affidavit? No. Magistrate, if you can't understand the affidavit, can refuse it, because there is not a duty cast on him. Under the Notaries Act, it is the notary, you go to the notary and then you say that under the act, you are bound to swear to have an affidavit sworn. Under the Oaths Act, a judicial magistrate will have to give an oath under circumstances mentioned in the Oaths Act. It is not every affidavit that a magistrate will be bound to do it. They are doing it because in certain cases notaries are not there, and so therefore they are doing it under the Oaths Act, but they are not bound to do it. No, section 80. Please come to section 80. I'll explain it to you. 80 says
80.
presumption as to documents produced as record of evidence. Whenever any document is produced before any court purporting to be a record of memorandum of the evidence or any part of the evidence given by a witness in a judicial proceeding, or before any officer authorized by law to take such evidence or a statement of confession by a prisoner or an accused, person taken in purported signed by any judge, the document is genuine, that any statement made to the circumstance under so and so made by a person signing it true, and thus such evidence statement of confession was duly taken. So that is the presumption under section 80.
Yes,
But you see, that presumption must be brought to the notice of the witness, or this accused person. You see, it's a circumstances operating against an accused person. So therefore, a circumstance which has not been brought to the notice of the accused under 313, can that be taken as an incriminating material against the accused person? That is the question. You see, presumption by its nature is always rebuttable. Correct?
yes,
A presumption does not make it a proof. It merely says there is a presumption that it is done in a good, true manner. You'll also find it in illustration E of section 114, that all judicial and official acts are done in accordance with law. So that is merely a presumption. Merely on the basis of presumption, can you convict a person?
no, that cannot.
That cannot be. So therefore, the question is based on those things. Other, if you can satisfy that section 80 requires dispensation of the proof of the precautions. You see, that is why we have got case laws on the point where the presence of a policeman in the courtroom itself become a proof to annul that statement or under 164. There are case laws where adequate time for not giving reflection to the person who is making a first statement not been given, that has been discarded. So if that presumption was final, then why we have those judgments where confession statements were not accepted by the superior courts?
Once the statement, confession statement has to be made by the convict voluntarily without any
It's supposed to be made. There's a presumption. But that was precisely my question is that presumption rebuttable or non-rebuttable? Or it is final? If it is final, then my query is that why the several courts have interpreted the confessional statement not being taken in accordance with law? Why there is why issue arose before any other court to discard a confessional statement altogether? Just a moment. As per the confessional statement, where is that confessional statement? Which page?
My lord, it's page 46.
46. How much time is given for reflection?
Well, it's mentioned first. Mary, before JMFC Burdumsa Changlan accused Manojit is brought by police Burdumsa PS on the day of 30/11/2016. 39 hours to have his confessional statement recorded. I have ascertained the offense was committed in Burdumsa area. The accused is also asked details as to length of time during which the place where he has been under control of police. The first place under observation from 1200 to 13 hours. Accused was brought before JMFC at date is not mentioned, hours not mentioned. Explain to him each of the matter mentioned in cautions, and he ought to be careful before making a statement as I place him in the charge of DA judicial. Armed police constable and I directed the accused to wait in one corner of my courtroom in order that he may have time to reflect before making a statement. I have satisfied myself that there is no police office in the
No, how much
courtroom.
time for reflection? That is the only thing
Yes,
I'm asking.
1 hour.
1 hour.
1 hour, yes.
Was placed under observation from 12 to 13. That's
Yes, yes. that's
1 hour.
much.
The next line is says gap. Accused was brought before the judicial magistrate Bombusa at so and so hours on so and so gap. The next line is armed police constable of and
Yes.
directed the accused.
Yes, my lord.
Armed police constable of, what does it mean?
Armed police constables of but in some there's some also some judgments also it says that the 164 statement has to be in question and answers form, but then this is not in question and answer form. That is one. Another is that minimum 24 hours the period should have to be given to the accused to decide. And then here, Your Lordship, the statement was before the ADC. ADC basically after with the in the record page
No, not
47.
ADC, it's judicial magistrate first class.
Yes, my lord. Later they have mentioned in the in handwriting it is the MFC.
I don't think they record here.
Except crept in, my lord. The prayer portion got exchanged, same petitioners.
Okay.
I may be allowed to withdraw with liberty to file it. I filed today.
Right, separate orders on the prayer made by Mr. D. Pangi, counsel for the petitioner. Permitted to withdraw this writ petition and file again, owing to certain error, typing error which is crept in the writ petition. Matter stands dismissal of withdrawal with liberty as prayed for.
My lord,
Yes.
my lord, I filed one writ petition this morning, my lord. It's a,
Please give it to the court master. When do
my
you
lord,
want?
I request for unlisted, my lord, because it's
Today.
yesterday only they uploaded the technical, wherein my technical bit has been rejected illegally, my lord. And today they are opening the financial bit, my lord. Last night only I got my lord. Deeply.
Also, I have a similar prayer for the
Time permitting,
Lordship,
time permitting.
if time permits, always.
Lordship, I may be allowed to listen for motion tomorrow.
Tomorrow, what is the urgency?
Lordship, we have filed a IA here. It's a matter of constructing a hydel. So it was to be listed after 3 weeks, but
My pleasure,
Yes.
Lordship. Lordship, I'm making this mention on behalf of my colleague, who is the counsel for the petitioner, item number 10, Lordship. Today he's indisposed, Lordship. Can this matter be taken up after 2 weeks, Lordship? There is also an interim interim order that may need to be continued, Lordship.
Yes, and the gentleman counsel, upon instructions, has submitted that the council holding the brief is indisposed and prays for adjournment. Prayer is allowed. Interim orders passed at this time extended. List after 2 weeks.
Oblige.
May I please, Your Lordship, I beg to item number 16, Your Lordship.
Item 16.
Yes, Your Lordship. Here the state respondent has filed their affidavit. So I would like to file one rejoinder. Your Lordship.
Okay. You have informed the other side?
Lordship?
You have informed the other side?
Yes, Your Lordship. I have already informed.
Okay. Both sides are represented on the prayer made by Mr. A.K. Singh, counsel for the petitioner. Matter stands adjourned today to enable him to file affidavit in reply if so advised.
2 weeks time, Your Lordship.
List after 2 weeks.
Much obliged.
Yes.
Lordship, I beg to mention one unlisted matter, WPC number 267, 2021.
What is the urgency?
Urgency is a service matter, my lord. This matter may be listed for tomorrow in order.
So some reason.
Yes,
Some
my lord.
reason. Some reason. What is? How is the petitioner affected?
Pardon?
How is the petitioner affected if the matter is not heard early? Because if it is a transfer matter, it is also a service matter.
Yes, service
And
matter.
after getting stay, people don't want to matter to be listed.
It's an urgent.
Yeah, yes. Yes.
Highly obvious.
Your Lordship, with the consent from other side, I beg to mention item number 29 to 32
29 to 32.
on behalf of a lawyer. Your Lordship, this letter may be listed after 4 weeks.
With consent of the other side, Mr.
Yes, sir.
Your name?
J. Karbak on behalf of K lawyer.
G.
J. Karbak.
G. Karbak. On behalf of Mr. K. Lawyer, counsel for the petitioner, place for adjournment, prayer is allowed. List after 2 weeks.
4 weeks.
4 weeks. 29 to 32.
Yes.
Yes.
Like.
May I, Your Lordship? Your Lordship, I beg to mention item number 11. On behalf of petitioner advocate Subu Koyang, who is currently out of station, your lordship. Therefore,
You've informed the other
prayer,
side.
your lordship?
You've informed the other side.
No, your lordship, actually.
No, then don't take an ex parte adjournment. No ex parte adjournment.
I have no objection.
No,
Otherwise, 2 weeks.
Rintu Saikia is there. Private respondent.
Lordship. In the meanwhile, I'll also file additional affidavit.
There will be
Lordship, yeah.
hundreds of good reasons. But when there is a respondent advocate,
Lordship.
without consent, praying for adjournment would not be appropriate.
Your lordship, as per my instruction, he is no more in this case. I'm not certain, but
Okay, then all sides are duly presented on the prayer made by counsel for the petitioner.
I list it
Matters
after
to
your
be
lordship,
adjourned today.
1 week.
Lordship, I will also file additional affidavit. Lordship, we have already filed, but
Okay.
we need to file additional affidavit.
Why is it required, additional affidavit?
Lordship, in rejoinder, they have, this is compensation, Lordship. We have paid already. They have said they haven't received. We are going to, basically for the document, Lordship, that we have the draft, payment draft. We need to file that document, Lordship.
No, you see, I have a very bad habit. I have an extremely bad habit.
Lordship.
Because when I fail everywhere else, I go back to my alma mater, which is CPC. Additional pleading, you must give reasons to why these additional pleadings are required. You see affidavit in opposition, affidavit in reply, after that affidavit in reply again.
Lordship.
The additional pleadings must be with the leave of the court, and you'll have to assign reasons why you need an additional pleading.
In our affidavit in opposition, Lordship, we have stated that we have paid the amount. Then in their rejoinder, they have Lordship said that they haven't received the amount. So we are, Lordship, basically for the bringing in the documents, that bank draft, payment bank draft. We need to file this additional affidavit to bring in the record, Lordship, the document.
This is G. Basar.
G at the Lordship. MSG at the Lordship.
G. I'm sorry, G. I'm forgetting all the names.
Lordship.
After a long time. G. Government advocate for the respondent number
Lordship 3.
3. This for leave to file an additional affidavit to bring on record the proof of making payment of compensation to the petitioner, which the receipt, the receipt of which is denied in the affidavit in opposition. First, prayer is allowed. In the meanwhile, the respondent number 3 may file additional affidavit.
Lordship.
Okay.
We did.
It's after a week.
Yes, Lordship.
Okay.
your lordship, I'm extremely sorry, I made a mistake, your lordship. Rintu Saikia is there. So he is in-
No, that's okay. That is over.
I'm extremely sorry.
Okay, that was item number
11.
11, your lordship.
11. Yes.
Oblige.
Obliged.
My lord. My lord, I beg to mention item number 9, my lord. On behalf of S.R. Rava, the counsel for this matter is out of station, my lord. And I have taken consent from the opposite party, my lord. So this matter may be taken after 2 weeks, my lord.
Okay. Consent of the other side. Counsel for respondent number. Which respondent?
Pardon, my lord.
You are for which respondent?
I'm applicant, my lord, here.
Hmm?
I'm the applicant here.
You are the?
I'm the applicant, my lord.
You're the applicant.
Yes, my lord.
Counsel for the applicant. Place for adjournment. Here is allowed. List after
2 weeks, my lord.
2 weeks.
My lord, otherwise also, my lord, connected writ appeal is pending. So
Pardon me?
therefore, that is the only reason, my lord, this matter has been kept pending, my lord.
Pardon me?
My lord, connected appeal is pending, my lord. Writ appeal, my lord.
Okay, is it?
Yes, my lord.
So
therefore, my lord, the once the writ appeal is disposed of, my lord, this can be, my lord, taken.
Is there in the record? I missed it. In this item number 9, is that retail reference is made there?
My lord, what happened in this case, when award was passed, against that notification as well as award, my lord, we, Union of India prepared the writ appeal, filed writ petition, my lord, and that was dismissed. The against dismissal order, my lord, the Union of India again filed the writ appeal, my lord, and writ appeal is still pending before this honorable court. And same notification,
no.
same plot of land. my lord.
No. I think it would be better if you get an order from the appellate court for staying off all the connected proceedings, because as a single judge, if that because writ appeal is pending.
My lord. This IA is for, my lord, the releasing of the amount, my lord, as per direction of this honorable court, we deposited the amount before this.
Then the appellate court will give a stay order not to release the amount. How can I, as a single judge, presume that the subject matter before the appellate court is same and then stay the disbursement
My lord,
subject to outcome of the earlier writ
my lord,
appeal?
there is a technical difficulty in the, while disposing of the, my lord, the applications filed by the Union of India, while disposing of, his lordship has not, my lord, specifically made any statements regarding the releasing of the amount, my lord. Therefore, my lord, in connected, my lord, IA 168, my lord, the applicant files for the release of the amount, my lord. And again, in item number, my lord, IA 219, Union of India file again another IA for releasing of the amounts to the Union of India, my lord. These are the, my lord, the board, the connected matters along with this item number 9, 340-74 is the connected matter, my lord, which is also subject matters in the writ appeal, my lord.
But then you'll have to move there. This court will be helpless.
My lord. And the last occasion also, my lord, this honorable court has passed the order for keeping the matter till the disposal of the, my lord, writ appeal, subject connected writ appeal, my lord. And there is a stay, my lord.
No, there's a stay.
In writ
Why-
appeal, my lord, there is a stay, my lord.
Visit order.
My lord, I'm
Is
sorry.
it- That's what I'm asking. Is it a part of record? I did not notice it. Item 9, I did not notice it. Because it will be the superior court will say the proceedings, not the not this court. It will be the division bench who will say that this implementation of this order will not be made.
My lord, by order dated 17 May 2023, my lord.
17 May.
My lord. In writ petition, my lord, 374. Least after 2 months, or least after disposal of the writ appeal number 41 of 2023.
This IA is for release of the statutory deposit.
My lord. And that has been, my lord, in the connected, my lord, the proceedings that has been disposed of long months back, my lord. But while disposing of, my lord, there is no any whisper about the, my lord, the releasing of the statutory deposit to either
You
to
take
the,
back, what is the, you see, that's why I was asking,
yes, my lord.
what is the impediment in allowing you to, this is by Union of India, you are Union of India,
Yeah, my lord.
and you are paying for a deferment.
Yes, my lord. My lord, the file these applications for refunding of the amounts to the, my lord, Union of India. My lord, after the disposal of the entire things, my lord, whoever is entitled, we are ready to pay, my lord. That is the whole period, my lord. Statutory deposit, my lord, what happened? It was, my lord, prepared before the, my lord, the
Just one.
district judge, my lord.
Just a moment. I'm not able to follow you.
My lord, may kindly pay you
Just
the
give me,
IA.
just give me 2 minutes. This LA appeal, is it before us? This writ petition is not a proceeding for under LA Act.
This writ petition is the press writ proceedings, my lord, after the disposal of the LA appeal, my lord.
No, you see, is it tagged with LA appeal?
LA appeal has been, my lord, already
This is
disposed
item
of.
number 9. No, this is item number 9. Just a moment. No, I hate this. I is in LA appeal. Then we are not withholding this. We are not adjourning it. We are allowing you this application. This IA 219 for withdrawal of the deposit. We are allowing it. We are not adjourning it.
My lord. In fact, the adjournment is, my lord,
My lord,
sought for
No,
by
you
the.
see, Mr. Kato, I'm not being able to follow you. Number one, you filed a LA appeal. That LA appeal was dismissed.
My lord.
Correct?
Yes, my lord.
After LA appeal is dismissed, your statutory deposit has to be returned to you.
Yes, my lord.
Now, even if you go to Supreme Court and challenge this order of this court,
My lord.
still that what you call that deposit, either you forfeit it to the court or you have to take it back. And supposing if the Supreme Court returns us back the appeal to be heard again,
Exactly, my lord.
then you'll have to make that deposit again.
Yes, my lord. That is the, my lord, whole period in our IA, my lord. 219, my lord.
Now, you see, is this 219 is what?
219 is our applications, my lord, for releasing of the amount to the Union of India, my lord.
Yes, we are allowing it.
Yes, my lord.
My lord, may I kindly submit, my lord? My lord, with due respect, my lord, I'm nowhere near to this case, my lord. This morning I have received call from the senior, and since he has asked me to take adjournment because, my lord, he's out of station, my lord. And moreover,
You see, this has got nothing to do with you. It's a, you see, let us give us a very easy example. Some of you may understand. You see, MSCT appeal is filed. And this MSCT appeal by the insurance is dismissed. If there's a statutory deposit made to the court and there is an application for refund, you have to refund it after the dismissal. How can we withhold that money?
no,
Will it
my
not be
lord,
illegal withholding?
my lord, that's
No, your prayer for adjournment has got nothing to do. We can't withhold illegally that money, whether you like it or not. The appeal is dismissed, end of the matter. And if
Lord-
the Supreme Court has stayed it, then it's separate. But dismissal of an appeal will be stayed by a superior court is very hard to accept.
My lord, may I kindly submit, my lord, in IA 168, my lord. Here, my
No,
lord,
one by one, 219. I am in 219. Please allow me
My
to
lord,
complete this
counsel
219.
has been changed in this matter, my lord. So,
I am not bothered. Is statutory, the deposit is with the court and the withholding of money would be illegal. Now, if you take an adjournment, can you give an undertaking? We'll record it that any interest required to be paid will be paid by you
my lord,
personally.
for that reason, my lord,
No, will
short
you,
that may be given, my lord.
are you agreeable to pay the interest, if any, personally? Money which I am holding is illegal. I want to refund it. You say, please continue to hold it and adjourn the matter. Now the question is, if somebody demands interest, are you ready to personally bear that interest? If you have a courage to say yes, we'll record it. End of the matter. We withhold that money. Correct?
Yes, my lord.
If I am ready to pay that money back to the party who is asking it.
My lord, my
I
only
can-
prayer was that since senior counsel is not here, and
No,
I have,
no, I'm not concerned with senior counsel or the prayer. It has got nothing to do with respondent. Respondent cannot have any say in a matter of refund. Correct? It's a money withheld by us in trust of the LA appellant.
because, my lord, in IA 162, I'm
I am
the
not
applicant.
in
my lord.
162, I am in 219. Please understand. Correct?
Yes, ma'am.
IA 219. This is an application for refund of statutory deposit lying with the court on dismissal. of LA appeal number 1 of AP of 2021 by judgment and decree dated, judgment dated 21 to 2022. Let's start. The
My lord, LA appeal 1 was not dismissed, my lord. It was disposed of with the directions to the learned court below for disposal of the matter, my lord.
I am not concerned with that. Your appeal here is dismissed. Your appeal here is dismissed.
LA appeal number 1 was not dismissed. It was disposed of with the directions to the learned court below to, my lord, heard the matter afresh, my lord. My lord, annexure 1.
Just simplify the things. This money which I am holding, you want me to retain it? You say that.
No, my lord. In fact, we filed application 219, my
So
lord.
then why is the objection in the
Yes,
present time?
my lord.
If the court has sent you there, we forfeit that money then, if you think so.
No, my lord. In fact, therefore, my lord, we have
Then take
retained
it.
the,
If I am ready to give it, please take it.
my lord.
In that, if you have an argument,
My lord.
we'll start imposing cost on you also.
My lord.
That when a court is ready to pay cost, refund the money, the learned DSGI is objecting to it, and therefore, what you call,
No, my lord.
interest will be paid
In fact,
to
we-
Union of India by you.
in fact, my lord.
Please don't,
My
these are
lord.
unnecessary arguments. I've got plenty of argument to hear today. Correct, this unnecessary argument, please withhold. You are tempting me to change my character by becoming rude to the bar. Don't make me rude. Rudeness is something I inherently know. I don't do it because of my habit, because of my nature. But please don't change my nature.
My lord.
Correct. First, he is praying for adjournment. We are pressing for an application for refund. When I'm allowing refund now, you are praying for an adjournment. Something
No,
which
no, my
is
lord. No, my lord.
absolutely
No, my lord.
what you call
In fact, time and again, we retain to the, my lord, the
please
registry
keep shut,
for.
otherwise I'll impose a cost,
My
a
lord.
heavy cost. My cost will be just like Supreme Court,
My
2 lakh,
lord,
2 lakh, 3 lakh, 4 lakh,
My lord.
that type. It's an unnecessary submission you are making. My announcement will be reflected in the order when I am imposing cost. Despite objection made by learned counsel for respondent number 2, opposite part number 2, the court is of the considered opinion that on dismissal of the LA appeal, the applicant is entitled to refund of the statutory deposit. So accordingly, the application stands allowed and the registry shall refund the statutory deposit submitted in connection with LA appeal number 1 of AP of 2021 to the applicant. This is disposed of. Yes. Now come to 168. Yes, what is the prayer here? You want an adjournment?
Yes, my lord.
Okay, so I have 168. On the prayer made by counsel for the applicant. You are the applicant here?
Yes, my lord.
The magistrate John today, Mr. M. Katolan, DSGI for the Union of India is present. List after 4 weeks,
2 weeks, my lord.
2 weeks. Okay.
My lord.
God bless, my lord.
Developer.
Yes,
May your lordship, I beg to mention item number 6.
6.
Yes, your lordship. Your,
Yes.
your lordship, the conducting counsel, he is a Guwahati-based lawyer, and he couldn't come before this honorable court today because
You're
of some.
taking consent of the other side?
Yes, your yes, your
Okay.
lordship.
With consent of the other side, miss?
Your honor,
No. Don't make a false submission.
but from the private respondent, I have taken consent.
No. Council means all the council.
Uh,
Council is also a singular word. Council is also a plural word.
Yes, your
Correct.
yes, your lordship.
Plural of council is council.
Yes,
It is
your
not
lordship.
councils. S is not added. Correct. So when I say council, you must mean all the council. Is objection, then you let the matter reach.
Yes, I was looking for
Let the
him.
matter reach. Once there is an objection, let the matter reach. Correct.
Your honor,
Let it reach. You know the prayer when the matter reaches. Correct.
Okay.
No ex parte order.
yes. Your honor, I want to mention even item number 24.
24.
Yes.
Here also same question. You have taken consent of council.
Yes, I have
54.
taken consent from the government side.
Okay. It's consent from the respondent, state respondent, the Ms.
A Talom,
K.
Talom,
Talong Leonard Council, please, for the petition, please for adjournment. Period is allowed. List after
3 weeks, Your Honor.
3 weeks. 3 weeks means you will do it on a vacation.
Yes, Your Honor.
Yes.
Yes, no.
Okay.
I mean, after vacation.
Then don't say that. Make it after vacation, because if the judicial order would be incorrect, then after 3 weeks is a vacation. Correct. Don't make the order wrong after the ensuing winter vacation. Because I believe in those stories, old stories. Walls have ears. Correct. If the walls have ears, you can argue before the walls and they will tell me. Correct. Yes, item 1.
Yes. By this writ petition, my lord, the petitioner is challenging by the impugned order dated 17 May 2023, my lord, by which the additional deputy commissioner, my lord, while functioning as the in charge of the additional deputy commissioner, my lord, he has cancelled the LPC, my lord. The LPC is issued under Rule 143 of the Arunachal Pradesh Land Settlement Rules 2012, my lord. This is issued, my lord, in exercise of the statutory power, my lord. And my lord knows that, my lord, law says, my lord, when a
Let us
person
see the impugned order. Where is that?
my lord will find page number 23, my lord,
23.
annexure 1, my lord.
No, but this proceeding was taken up, you were given opportunity.
No, my lord. Here, my lord, opportunity in this sense, my lord. Only, my lord, I have stated in my petition, my lord, that, my lord, I received the summon, my lord. I appeared, my lord. I submitted the representation, my lord. And following which, my lord, that a mail order was issued, my lord, for holding the kebang, my lord. Then I intended to participate, my lord. Then, my lord, that owing to the non-presence of the opposite party, my lord, that was postponed, my lord. Then subsequently, my lord, again mail order was passed by the deputy commissioner in charge, my lord. But here, my lord, very interesting. What happens here, my lord? One clan-based organization, my lord, interferes, my lord. Now, clan-based organization in the name of Nabam Welfare Society, this is a clan-based organization, it interferes and writes a representation to the additional deputy commissioner saying that you don't proceed with the proceedings of the Kebang, we will settle the matter since this matter has been pending with us, my lord. Thereafter, what happens, my lord? A report is filed by the, my lord, this clan-based organization, my lord. And on the basis of that clan-based organization report, my lord, this impugned order has been passed, my lord. My lord, basically, I have 2-3 grounds are there, my lord, on the basis of which this has been challenged, my lord. First, my lord, he has no authority, my lord. Because statutory power cannot be exercised by the official, my lord, holding the power of in charge, my lord. First ground, my lord. Therefore, my lord, without any authority, per se illegal. Because substantive power cannot be exercised.
So you go to the root of the matter, root of our existence. Now, in the Guwahati High Court, there is an in charge, acting Chief Justice. So what happens to the proceedings?
So far, administrative is concerned, my lord, that is different. But so far, my lord,
no, we are doing both power. We are exercising power judicial side.
Some judgments, my lord, this Karnataka High Court, some judgment have been referred and rendered.
Once somebody is in charge, he's in charge for everything. You see, you have, Mr. Sonar, you have done hundreds of cases. Officer of the rank of, let us say, I'm making things lighter. Let us say the government in its all wisdom thinks that a grade 3 should be made in charge of a post which is grade 2. Can it be done?
My lord, so far, my lord, my argument is based on the judgment, my lord, rendered by the High Court of my lord, other High Court. I will place that, my lord will consider that part. I will say. And thereafter, my lord, other ground. First, my lord, thereafter, my lord, this purported inquiry, my lord, that has been done behind me. Neither complaint copy has been furnished to me as on today, my lord.
no inquiry report, my lord. And so far, now they're saying that some statement have been recorded. These all are behind my back, my lord. As on today, my lord, I have not been, my lord, furnished with all those documents. Third ground, my lord, that this order has been passed, my lord, at the base of one clan-based organization, my lord, which I will show from the record itself, my lord, that before that, my lord, I will show this judgment, my lord. It says, my lord, that saying that, my lord, so far, my lord, this first part, my lord, that in charge cannot be passed, my lord, this order, my lord.
Almost more than 50% of schools and colleges
My
will
lord.
be running by in charge.
Reasoning has been given, yes,
In charge principle.
my lord. My lord, first, para one, I will start from para one itself, my lord. The question for consideration in this petition is whether an officer holding a post or in charge basis can exercise the substantive power of the post, my lord. This is the issue, my lord, raised in the writ petition, my lord. Thereafter, my lord, straightly I will go to paragraph 11, my lord.
Just a moment.
Para 11, my lord.
Just a moment. Okay.
My lord, one more judgment is there, my lord. Is here, my lord, also, my lord, Deputy Superintendent of Police, while holding in charge of Superintendent Police, my lord, issued initiated department proceeding that has been passed, my lord. Para 3. So, my lord. Para 3, my lord. Yes.
This, the officer who's passed the order is of which rank?
My lord.
The officer who's passing the order is of which rank?
Pardon.
What is the rank of the
My
officer?
extra assistant commissioner.
Extra assistant
Yes,
commissioner,
my lord.
and he's performing the job of a
In charge, additional deputy commissioner.
additional deputy
Yes,
commissioner.
Is a
Yeah, under the Arunachal Pradesh service rules, is a person of a rank of extra assistant commissioner. He is prohibited by any rules to take up the to be appointed as a ADC. Does he hold qualification to be appointed as a ADC?
ADC. Appointed, my lord, it has to be, my lord, he has to be under this.
No, is there a difference of rank between
My lord,
ADC and
there is some, I think after admin grade, I think they will be, they are eligible, my lord. There is a grade in this civil service also, my lord.
Now, is there any prohibition in the Arunachal Pradesh for the tenure of the in charge posting?
My lord, that I don't have knowledge, my lord.
Because you see, in this Karnataka rules which you have placed before us, this judgment,
My lord.
IRR 2006 Kerala 3163, they have referred to rules 32 and 68. 68 says sanction of a government should be obtained where the in-charge arrangement is proposed to be continued beyond 6 months. So therefore, there is a prohibition in the act. I am reading that. I have opened up this Karnataka Civil Service rules, and the tenure of the officer who is having otherwise being in charge is full charge. Thirty-one, 32. This is 32. In 32, it has several parts. One says that continuation of independent charge arrangement beyond 6 months and payment of charge allowance. Financial powers delegated to such to the secretaries of the government are full powers. And then in note 3, it says the duration starts from 2 months when they have all full powers. In 32. So therefore, there is a limitation in the Karnataka Act for appointment on ad hoc basis without the sanction of the government. If that parameter provisions are not available in Arunachal Pradesh, I don't think this judgment cited would be a binding precedent.
Well, basically, my understanding of the judgment is that whenever a person is appointed as in charge, he cannot day-to-day administrative service he can function. So, for my understanding of the judgment, that so far substantive power is concerned, that are the statutory power, which are conferred to a particular post by way of statutory. That power, because unless a person is appointed to that statutory post,
I'm sure you, because this is
what my first impression of this particular judgment.
Okay, but I'm reading that Karnataka rules.
So first ground, that part.
Civil Service Act.
First is without authority, will determine that question whether has the authority or not. First ground, challenge is that without authority, that even since he was acting as a in charge. The second ground, this is a quasi-judicial power, exercising not administrative, because civil consequences entail here, and suffering the right to property. So, when exercising the quasi-judicial power, the principle in nature has to be scripturally followed.
How can you show that natural justice was not?
Not at all,
It shows.
As on today, no the complaint letter has been given to me, not the inquiry report, and no chance of,
No, where is your statement to that?
Statement, para 22,
22.
From
what I've understood here is that the property belonged to your brother.
No, my
And
lord.
the brother died, the wife and children are the dependent.
My lord,
And you claim that you have otherwise not disposed of the property of your brother
my lord.
and you are taking care of them.
No, not like that. Here is something happened, my lord. Here is, my lord, altogether, my lord, two plots of land, my lord. One is located at Kokila, one is Kolongi, my lord. Then what happened, my lord, so far, Kokila lane is concerned, there was, my lord, 95,000 square meter gifted by one other person, man. So that was gifted to both, to me as well as to my younger deceased brother, my lord. So what I did is, my lord, partition, half portion of that 95,000, I took the LPC. And half of the portion of that LPC given to the only son of the deceased younger brother. Son of the deceased younger brother. So thereafter, my lord, so far the land is at Holungi is concerned, my lord. That is my own private land. Now what happened here, private respondent, the eldest daughter of my deceased younger brother, she files a complaint. I don't know what is the content of the complaint, man, as on today. Then when she files the complaint, my lord, very interesting, matter would have been very easy. I will show from the annexion, my lord, how because of the interference of the third party, all these things problem have created. My lord, may I take to kindly to straightly I will take to my lord page number, first my lord, page number 30.
13.
30, man.
No, the statement first that no copy has been.
My lord. Page number 22, I start from page number 22. May I read, my lord?
Yes.
Yes.
Para?
Para 22, my lord. It is most of you submitted the response while functioning as in charge has passed the impugn office order most illegally, so and so in violation of the principle of major administrative action. As the writ petition has not been provided with any reasonable opportunity of hearing before passing the impugn office order, despite the repeated requests, the writ petitioner has not been provided with the copies of the complaint, the purported inquiry report, and the statements of the boundary owners and other relevant documents on the basis of which the impugn order has been passed, my lord.
Then we said we have to state. We said we have to state. The copies have not been served. LTC is cancelled.
At this stage, only notice may be issued.
But that has to be stated.
Other party are also there.
No, but that has to be stated. If that land he misses out.
In charge has, because the in charge has issued.
No, it's not a question of in charge. That I am not accepting for the time being. But if the LPC has been cancelled without issuing him
Lordship,
without
that is
giving him
his-
copies of
that is
the.
his statement, Lordship, but then in this order, cancellation order itself, Lordship, it has been mentioned that we have been given notices many a times, Lordship. On 6, 5, and then on 24th April, and then one is off, Lordship. They have annexed here one. So let me take.
My lord will see.
Let me file my instructions, Lord.
Just on.
In the last para, Lord. Page 23 in the last para, Lord. And since Lordship, there is a serious allegation that he has fraudulently, Lordship, managed the signatures, Lordship, NOC from the concerned boundary owners and then from the GBs, Lordship.
Please read that part. Notice has been sent. Please read that part.
Lordship.
Second last paragraph. As per the finding and recommendation by Rome Mele,
Yes, CO.
Circle Officer Balijan Taraso, Inquiry Officer, as well as frequent notices served to so and so and so and so so and so. Opportunity of being heard.
And further frequent notices served to Sri Navantadi, who is the petitioner, dear Lordship. On so and so and so and so. Lordship. Lordship, some.
Yes.
My lord, may I take to my lord,
sentences are not
page number
clear,
39, my lord.
39.
39, my lord. Because during the holding of inquiry itself, my lord, I wrote the application saying kindly furnish me the details of the document. Page 39, my lord, second paragraph. Therefore, your good office may supply the complaint copy with other relevant documents made against my land. Provide me with the following information, my lord. It's all, my lord. This was on 8/5/2023, my lord. My lord, other series of representation I filed, my lord. Seeking, my lord, documents.
Interim may be considered on returnable debt. Lordship.
No, no. If the FPC has been cancelled, there has to be put a status quo on that.
Deeply obliged.
My lord. My lord, on instruction, my lord, for respondent, private respondent, my lord, my lord, I'm instructed to appear, my lord. But earlier we filed a caveat also, but the caveat is because of the lapse of time, my lord. It could not be taken, my lord. My lord, here, my lord, this entire property of my deceased father, my lord, that entire, not only the landed property, even entire, all the ornament has been taken by the petitioner, my lord. We have been left helpless, my lord. And we are, I mean, all the family member, my lord, they are helpless. All the student, my lord, the private respondent is the eldest sister, my lord, and the family, my lord. Now, taking advantage of the deceased father, my deceased father, no? After that, he have taken all this thing happen. After come to know, we have approached the authority, my lord, these things which required, my lord, elaborate hearing, my lord. My lord, we'll be filing a wakalatnama. It's a serious matter, my lord. This is not a case that is they projected, my lord. This entire property that's been seized has been taken by petitioner, my lord. They will, even if, my lord, he will not be.
Did he get an opportunity to was he served with a copy of the complaint and then so available?
No, not that.
My lord, it is his version, my lord. Now, my lord, impugn order.
Even, my lord, village authority mail was constituted. But
mail is something not to.
Yes, my lord. Matter could have been decided there also, my lord.
No, we are not. LBC, we are not concerned with mail.
My lord, at least that determination has to be in accordance with law, my lord.
Can't do it.
My lord, in the impugn order, my lord, I'll just read the page 23, my lord. There itself it's reflected, my lord. My lord, last paragraph, my lord, Mr. Nabum Kanam, my lord. I'll start from Nabum Kanam. Page 23.
Yes.
Last, Mr. Nabum Kanam or Nabum Kanama, as mentioned in LPC application form, who is also the son of late Nabum Tata, has written to the office of ADC Balijan stating that he never applied for an LPC nor signed to confirm Mr. Tadik ownership of the mentioned plot. He has requested the cancellation of Nabum Tadik's LPC for this case. As per the finding and recommendation of Sri Rome Mele CO Balijan Taraso, inquiry officer, and the frequent notice served to Sri Nabum Tadak on 6 May 2023, 7 April 2023, 24 April 2023, and further opportunities served of being heard. I, this show, my lord, hereby cancel the LPC, my lord. It's not a case, my lord, notice was not issued. He was given several opportunities.
Okay. But you see, the next page is showing us which page? Page 23. No, not 23. This, which page you showed us? That he, on 8/5 you wrote. Where is that?
My lord.
8/5 representation. Where is that? 8/5
representation, my lord.
Yes.
Page 39, my lord.
39. There's a receipt number of also from the office of.
Yes, my lord. Repeatedly filed, my lord.
if he doesn't get it. And number two, second question is that finding which you have read,
My lord,
that finding which you have read, I cancel the
my lord.
LPC. What is the reason assigned? Why is it cancelling it?
My lord,
That's why lordship will take instruction.
No, no,
lordship.
no.
Okay, just
No,
one
no,
week
no.
time maybe
No,
allowed
no.
that.
You see, you get time, I'll give you a year time, don't worry. But the question is, in this, from this order, what do you get? Why is the LPC cancelled? Your stand is okay. He's your worst of your brother. He has usurped all the properties. He's one of the worst men in the state of, in the state. But why it is cancelled?
my lord, in the impugn order, my lord, is also on my lord, it's as per my instruction, my lord, the entire landed property belongs to my father, late father, and he has been illegally he has captured and obtained the now LPC. Now LPC here, impugn order itself, it says that even how he has obtained LPC by forging the signature of the neighbors, my lord. That is, it is written, my lord. Fraudulently, he has obtained LPC, my lord. In the impugn order itself, my lord.
No, supposing today somebody alleges fraud. Who determines fraud?
My lord.
Who is the authority assigned in law to determine fraud?
My lord, that part, my lord, the criminal case could have been registered, my lord.
You see, somebody says that this is not mine.
My lord.
Mere statement will constitute fraud. The
My lord,
ADC has erred in finding. Has he recorded the statement of the person? Privacy agreed. He wants a copy, you don't give him a copy. And then you decide fraud.
Lordship, that is his statement, lordship.
My lord, it is
Statement.
Has to be stated. This
My
has to
lord,
be stated.
Mr.
It's given up not.
This has to be stated. The status quo has to be maintained.
Yes, much obliged, deeply obliged.
It can't.
Lordship on returnable debt.
No. On returnable date, we'll give you opportunity to vacate.
Pass when May.
May 23, my lord.
There is no
Now,
urgency, lordship here.
No.
as of now, my lord, the property, my lord, that we cannot say as of now, because practically land belongs to the private respondent, my lord, his
No, it's
late
okay.
father, my lord.
That will
Now-
be
now
determined by
that-
the civil court, my lord. The title goes to him, not here, my lord.
Now
The
here-
reference has to understand that.
Even third paragraph, my lord, it says, even the statement of the neighbors were recorded, my lord, who say that he has obtained the signature, forged signature by doing fraudulent play, obtained the LPC, my lord.
No, you give him a copy and then allow him to proceed.
It is in state, my lord.
Statement now, lordship.
He can say anything, my lord.
Till 4:30 we can wait. You ask your ADC to give you a, what you call, send you a scan copy right now in your mobile. 4:30, we'll wait till 4:30. If you can get that he has been served with a copy, end of the matter. Tomorrow
My
morning.
lord, tomorrow.
The both sides are represented. This GATL and government advocate prays for time till 6/11/2023 to produce relevant instructions as to whether the copy of the complaint was served on the petitioner pursuant to his representation.
Or as well as my lord, inquiry report.
No, it's
Inquiry,
not a petition,
basically.
petition, or if you have got petition, that's end of
My
the
lord.
matter. Petition. List on 6/12/2023. Give him a copy.
Copy, my lord.
Give him a copy. Read petition, give him a copy.
Copy.
Then so far notice to private respondent can be dispensed. He has a.
Give him a
Well,
copy.
I'll file the
Tomorrow we'll pass
wakalat.
orders. We'll pass orders tomorrow. Because his Vakalatma is not there, I have not recorded his presence right now. I just recorded the presence of the government advocate. But you give him a copy. Item 2. Your citation, Mr. Sunar. Yes.
May I please, my lord. My lord, I'm challenging the interim order dated 6th of November 2023, my lord, which my lord you find at page 20, my lord. My lord, I'm a woman, my lord. I have constructed.
Just. I can only issue a notice right now.
My lord, that's an interim prayer, my lord. That interim prayer, my lord.
No.
My lord, till returnable date, at least, my
No,
lord.
no.
May I humbly pray, my lord.
That will
Otherwise, my lord,
of the entire relief.
my lord, may kindly appreciate the fact that, my lord, that hotel was given on lease, my lord, to somebody else. I'm not privy to whatever has been
By way of an
going
interim
on,
order, I can't allow your petition.
my lord.
By way of your interim relief, I can't allow your petition.
My lord, my lord, my whole
If you press it, I have to reject it. So
my
instead of
livelihood
that,
depends upon
no.
the income of that hotel, my lord.
No. Because drugs were seized from that premises.
My lord,
Drugs were seized from that premises.
my lord, that manager has been arrested, my lord, and subsequently he has been released on bail, my lord. And my lord, appreciate, my lord, that hotel was leased to the respondent number 3, Bay Wagon 2020, my lord.
You see, the difficulty is that there are things I can't read. Correct. This is a document which I can't read under section 49 of the Evidence Act.
My lord.
Oh, sorry, Registration Act. Section 49 of the Registration Act.
My lord.
It says, it starts with a non-obstante clause. No court shall receive in evidence a lease agreement which is purportedly creates a lease of more than a year.
If my lord permits, my lord,
Yet you don't have a limit. This is a perpetual lease.
My lord.
You don't have a time limit. This lease agreement which you have shown at Annexure 3, it does not have a time. So it will be considered as a perpetual lease. And section 49 says it will not be received in evidence.
However, my lord will appreciate that it was on lease, my lord. And then, my lord, the moment I came to know, my lord.
Mr. Lodhi, if I can't read, I can't appreciate.
My lord. But from the
Showing Registration Act, section 49. No, wait. Sorry.
Okay.
Correct. No court shall receive in evidence. No, I can't read. That's the difficulty.
But then my lord may kindly appreciate the fact that my lord, even if I was the owner of the
ex parte order, I am not passing. When the drug is seized from your premises, ex parte release of property.
the manager who was arrested, my lord, and now he has been released on bail.
We don't know because in NDPS cases, once the property is seized, it will be subject to seizure.
My lord,
what you call proceedings. So therefore, I am not scuttling a seizure proceeding with an innocuous order. That I am not doing. And so, Padal and counsel for the petitioner. And
but at least may humbly pray, my lord, the entry may be considered on the next date fixed, my lord.
So, has the government advocate appearing for all the respondents?
1 and 2.
For respondent number 1 and 2. you're pushing me to a corner.
my lord.
Mr. Vara, you're pushing me to a corner where you're inviting an adverse order. You know why?
My lord.
Once you say that the premises is a leasehold premises given to others,
My lord.
by my order in a writ petition, you want to take over the property without filing an eviction suit. I would have dismissed this in limine, but I'm asking you, I don't want to dismiss. Today is my first day, I don't want to dismiss it in that manner. But please tell me, if you are pushing me hard, then this is the third question I'm putting to you. A premises is under the occupancy of a tenant.
My lord.
Now, are you the occupier of the premises? Can you be said to be an occupier of the premises? No. Once you are not the occupier, you are a landlord. To resume the property, you will have to file a title suit. That leads to dismissal of the writ petition now.
I appreciate that.
I told you.
My lord.
That's why I'm putting you to a forewarning before dismissing. That this writ petition would not be maintainable. I'll be dismissed, I'll be compelled to dismiss it now. You have to file a civil suit and get it recovered. You can't be given a tenant premises at any point of time. Once you admit that it's a tenanted premises, then only a tenant can now get it. I'm sorry, I'm a government advocate appearing for the respondent number 1 and 2. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has not only prayed for setting aside and quashing of the cancellation order dated 6/11/2023, by virtue of which the license of the petitioner to operate his hotel business. Where is that document?
Page 20.
Order. Page?
MP in order, my lord.
Yes.
Page 20, my lord.
28.
No, page 20, my lord.
20.
Is the order, MP in order, my lord.
Which, by invoking the provision of section 18 of the Immoral Traffic within bracket Prevention bracket Close Act 1956, the trade license of the petitioner in respect of Mrs. Hotel Lowland, LOLLEN, Palace and Restro was cancelled till further orders. But the petitioner has also prayed for recalling or directing the respondent authorities for revocation of the said cancellation order dated 6/11/2023. The learned counsel for the petitioner has submitted that the cancellation of the trade license was made by the Deputy Commissioner from West Kent District on twofold allegations. Firstly, of carrying out using the premises for illegal and immoral purposes, and that the manager of the said hotel was arrested in connection with Alok PS case number 47 of 2023 under section 22 within bracket small b, bracket closed of NDPS Act. First off, in the said context, it is submitted that in the said context by referring to Annexure C, which is an agreement for lease of Hotel Lowland Palace, which is dated 1/9/2020. It is submitted that the said premises was leased out to the tenant, and therefore the petitioner was not responsible for whatever has happened in the tenanted premises. It is submitted that the manager of the said hotel was arrested in the NDPS case, and therefore the penalty imposed, the action taken by the respondent authorities in cancelling respondent number 2 in cancelling the trade license of petitioner is unwarranted. Next, having regard to the nature of grievances raised by the petitioner, and in light of admission made by the petitioner that the hotel property was leased out to a third party, who is read herein as respondent number 3. The court is of the considered opinion that unless the said lease is terminated in accordance with law, allowing the petitioner to resume charge of the said hotel, the petitioner would have no cause of action for agitating the order of cancellation of the hotel license of the petitioner. Full stop. In the further considered opinion of the court, the property being vested with the respondent number 3 includes the consent of the petitioner to the respondent number 3 to run the hotel business. So therefore, during the currency of the leasehold, the lease, the petitioner would not have a right to maintain this writ petition for indicating the cancellation of the said license. Next one, be that as it may. In the event the petitioner gets to resume the property, it will be open to the petitioner to take an appropriate measure as he may be so advised for the in respect of the trade license of the said hotel.
My lordship.
Yes.
This is lordship regarding lordship appointment issue. This I'm agree with the appointment order issued by the state respondent with regard to
just a minute.
appointment of the private respondent.
Just a minute.
This This is with regard to appointment of political assistant. Kindly see the page number 34A.
And it should notice at this stage. And it should notice at this stage, it's challenging the appointment, promotion in fact.
Promotion, Your Lordship.
Yeah, challenging promotion.
Yes.
Okay. That is a T Apartment Council for the petitioner and Ms. R.
Arbasa, Your Lordship.
Learned government advocate appearing for the
1,
respondent
2, and
numbers
1, 2, and 3.
1, 2, and 3. After that, the promotion to the respondent number 4. To the post of
Political assistant.
political assistant is under challenge in this petition filed under Article 226 of the Constitution of India. You should notice returnable. If you notice, including notice on the prayer for interim relief, returnable in 4 weeks. Requisite extra copies of the petition be served to the learned government advocate within 2 days. The petitioner shall take steps within 2 days for service of notice on respondent number 4 by registered post with AD. As well as by email. You will have to serve it by email also. You have email address.
No email address at the, it is the interior area. This is a rigor with regard to political interpreter. Whether attest with the deputy commissioner office at Inkyong.
In addition, notice will be served on respondent 4 by mail. By routing the process to the registry of the court, and upon service an affidavit of service shall be filed prior to the next bit of the next paragraph. The appointment of the respondent of 4 to the post of political assistant shall be subject to further orders that may be passed in this application.
Lordship,
Just a minute. Just a minute. Given decision, are you not required to challenge it in the civil court?
No, this is first of all, there is a procedure violation in the case. That is why I have filed this case in the form of writ petition. There is, Lordship, kindly see page number 18.
No, after
Yeah.
execution, how can a writ court entertain the, how can the writ court entertain the challenge?
Lordship, I am challenging the decision of the village authority. Page number 18.
No, but after execution, you see the order has been executed. It's your own case that the order has been executed.
Yes, Lordship.
Then that is why, Lordship, this
Then the order of the Kebang must be challenged where? Under the, under this Assam Frontier Regulation, which is the authority for before where the challenge can be made.
After execution, Lordship, there is no remedy
No, Mr.
left.
Rabak, I find difficult to
That is,
accept your
that is why
submission.
I have
I'm
filed
telling you, I'm finding it difficult to accept.
superintendent's direction.
Please understand me.
227 of the Constitution.
Please understand me. I have difficulty in accepting this because of the fact that you see your prayer at page 8. I read in the nature of certiorari, for setting aside and questioning the imperial order dated passed in execution petition number so and so. And Bangu Kebang dated so and so.
Yes,
Now this Bangu Kebang has been executed.
Yes.
This order has been executed
yes.
on 13/3. 13/7.
Kabang dated 15 November 2022 has been
Yes.
executed without my presence.
No, execution, you don't need your presence. In execution, we don't need your presence.
It is informed to the other party. Execution process is that. If order is passed, then after execution, this application is written to the authority that is as per the regulation act. It may be before the deputy commissioner or assistant commissioner. The ADC, in this case, the ADC was, ESC was acting as an assistant commissioner of the area, leaving the assistant commissioner. He has executed, purportedly executed. This is the issue. Whereas Kabang is on the way. Kabang is yet to be completed. Kindly see page number 18. In the village Kabang, as per the decision of the village Kabang, it is clearly that party were given at liberty to settle the matter and to report it to the court. This is village
I will not be
authority.
able to follow you. I'll tell you why.
To report the matter to the village
I'm
authority
telling
again.
you- I'm telling you why I am not being able to appreciate your high court rules. Look at this. This is appendix 22. And Guwahati High Court Superintendence of Tribunal Rules.
Can this, Lordship, can this matter maybe fix? I will go through this after break.
No, unless you see what I'm showing you, you can't go through it.
Yes, yes. Appendix customary code 10,
Yes, and there is a schedule given.
schedule 6.
227 can be exercised, superintendent jurisdiction can be exercised only on these matters.
Yes,
So you can't resume jurisdiction which is not there.
yes.
That is number one. And also tell us the law that this Kebang decision is one part. But if you're challenging it, it is in fact a challenge, a inter-party challenge.
Yes.
In a writ petition, can we entertain that if it is a writ petition under 226?
226 and 227.
No, two provisions can't go together. These are two different road altogether. One is a tram line, one is a high-speed rail.
227 is for revision.
So either you choose between the two.
What is the power?
Either it is 226 or it is 227.
Yes.
Because the Supreme Court in decision of what is that?
This. Lordship,
There are a series of 3 decisions, including a division bench decision that Surjadev Rai has been overruled by a 3-judge bench, but the finding on one part is same, that a 227 cannot be said to be a writ. Therefore, 226 and 227 can't travel together.
Lordship, first of all, I would like to submit this. This issue disputed is a WRC field. This is their foreman, and they have to go to the Supreme Court.
No,
It
I
is a
can have,
big
I
issue
can,
here.
because I can have
So
sympathy.
I will go through it and
Okay,
I will try to
okay.
understand this case and
Okay.
matter will be fixed after
Okay.
break.
But here also one more thing, you don't have to go to Supreme Court immediately after my order. You have an inter-court appeal also. Correct? So don't think of Supreme Court. You have an inter-court appeal also. On the prayer made by Mr. T. Tava, Counsel for the Federation, the matter stands adjourned today. Ms. G. Patel and Government Advocate is present. List after?
After break. after break, after vacation.
We started everything after saying winter vacation.
Your Lordship, I have taken consent.
Yes, can we adjourn it?
Yes.
Yes.
7, Lordship.
It's, yes, fixed date may be given, Your Lordship, on
7th of
December, this.
7/12.
They-
No, not 7, make it 8. 7th, we are reserving it for some hearing matters. 8.
Your Lordship, the council is coming from Guwahati and he have matters on 7, so.
No, 7th, I am reserving it for a hearing because today also I have referred one division bench matter here on 7th. Make it 8.
Your Lordship, interim is there, interim may be continued.
Both sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned today, based on 8/12/2023.
Here, Lordship, on earlier occasion, I was asked to produce the records of the petitioner, Your Lordship, but I regret to say that till date, I have not received it. One last opportunity may be given to us.
There is no representation from the petitioner. On the prayer made by Mr. I. Viram.
Why Ram, Your Lordship?
Why Viram, then government advocate, the matter stands adjourned today.
Yes,
List after
2 weeks, Your Lordship.
2 weeks.
Obliging.
Your Lordship, this is an writ petitions for grant of pension.
Yes, what is your stand?
Lordship, earlier, last occasion, Lordship, the court asked me to take some instructions from the Honorable Court asked me to take some instructions from the police department as well as from the
Government.
pension, audit and pension department. I am in receipt of the instructions, but they are not very clear, so Lordship. This morning only I received the
No
instructions.
problem. We will have a table made outside. They can come day after tomorrow and give you instructions. We'll ask all the head of the department to be here in their corridor.
Lordship, this can be taken up day after tomorrow also.
But if they don't give you instructions, then what? We'll make them work in our, we'll give them hospitality. We have our armed guards here. They will guard them. Nobody can disturb them in working. You see, somebody is asking for pension and you say from 2022, you are not getting instructions. So let me.
No,
call the-
Lordship, affidavit we have already filed.
Then tell us,
From both-
take this stand.
Lordship, then matter may be taken up.
Take this stand. After affidavit, what stand, what stand you want? In your defense, what you have stated?
Yes, your Lordship, yes. I was retired from the job on 31/1/2022. Accordingly, I had applied for the
No,
pension.
I'm not asking, I'm asking Mr. Dete.
Madam.
Lordship,
Yes.
Lordship, just a second. Lordship, he is a police personnel, Lordship, because
No, no, I'll tell you what your stand is. Why,
Lordship, our stand is, Lordship,
you
will-
see, come to page
Lordship,
4.
page 4,
Yes.
para
Now
5.
he has constructed a house there. And you have,
Lordship, inside the police, Lordship,
it's okay.
colony.
It's okay, but you say that he has not demolished the house. No, is he's staying there?
Lordship, his kitchen cleaner is staying there.
Huh?
His kids are staying there now.
He's still staying there. Correct.
Not him, but
No, not.
no, he has retired already. He's not staying there, but his daughter is staying there, saying that he's attending college. Lordship. He has
Okay.
not.
So this police authorities, they are helpless to evict this girl from there.
Lordship, he have given in writing that he will, Lordship.
No, that is okay. But you see, you are withholding his pension. Now, number one, just like power vested in the authorities, has the governor reserved the right not to release the pension?
No.
In this case.
Lordship, no, not as such.
So therefore, if the governor has not reserved, while he is superannuity, the governor has not reserved the right to withhold his pension. How can you withhold that pension? And if the police is powerless to evict one girl from their campus,
Lordship, since
I think the entire police should go and the new police people should come. How will they protect, what do you call, in Supreme Court has used the words for ordinary men. The Supreme Court has word little men. You are aware of it? Nisete. Supreme Court, while referring to common men, have many a times used the word little men.
not
So little men like us, who will protect them? If the police is powerless to evict one girl from inside their campus,
Lordship, with the kids there, Lordship, it's difficult to evict them, Lordship. We have tried many times, Lordship, the department has.
girl is so
Lordship.
strong.
Lordship, I understand.
Very good. If the girl is strong, you leave it, allot that land to her.
Lordship, already the
No, but tell me that under your rules, act and rules, relevant, which are the pension rules, which is in vogue in the state, for not leaving the premises. You did not draw up any proceeding against him. Right?
No.
The right to withhold the pension has not been invoked. Now, how do you derive that power to stop pension?
Lordship.
Just show me the rules and then pension rules and then end of the matter. Third,
Lordship.
Mr.
DK Deori.
D.K. Deori, counsel for the petitioner. And Ms. G. Atel, and the government advocate appearing for the respondents. Next paragraph. By filing this petition under Article 226 of the Constitution of India, the grievance expressed by the petitioner is that he is a retired police personnel. And although he has superannuated and released from government service with effect from as a head constable with effect from 31/1/2022, by the order dated 21/1/2022, he has not been paid his retirement dues. Full stop. It is. Where is the reply of the Superintendent of Police?
Four and six.
The petitioner relies on annexure 3 to the petition, which is a reply, which is a letter dated 7/7/2022 by the Deputy Superintendent of Police within bracket HQ headquarter bracket close Longding district, indicating that a departmental inquiry was initiated against the petitioner by order dated 11/7/2016, which is yet to be finalized. Although the departmental inquiry is reportedly completed. First of all, there's the according to the subject that till date the pension and other retirement dues of the petitioner has not been released. Next paragraph. The learned additional senior government advocate has submitted that the petitioner had constructed a house within the police campus, which has not been demolished. And according to her instructions, the daughter of the petitioner is still residing inside the said house. That despite efforts made by the police authorities, they have not been able to evict the daughter of the petitioner from the house situated within the police campus. The additional senior government advocate has also referred to the annexures amended to the affidavit in opposition filed by respondent number 4 and 6. The project that show cause notice was show cause notice in connection with departmental inquiry was served on the petitioner, along with statement of article of charges, statement of statement of imputation of illegal acts committed by the petitioner, pursuant to which an inquiry was conducted and she relied on the inquiry report. Proposing award of suitable punishment against the petitioner. First of all, they said inquiry report is dated 9/2/2017. Be that as it may, it appears from Annexure 2, Annexure E to the affidavit in opposition that by an order dated 21/11/2018, the petitioner has been exonerated of the charges and his suspension in effect from 8/3/2016 to 10/7/2016 was ordered to be treated as spent on time spent on duty for all intents and purpose. And that the power by an order dated 31/8/2022. The Assistant Inspector General of Police within bracket E in exercise of power under Rule 13 of the Arunachal Pradesh Police within bracket Discipline and Appeal bracket close rules, 1999, read with has amended, imposed a penalty of censure, CENSURE. However, the period of suspension was ordered to be treated as spent on duty, and further penalty was imposed on the petitioner withholding 3 increments with cumulative effect.
No, not that.
Lordship,
No.
may I? Lordship?
Since serial number 2 is not the petition.
Lordship, that
only one.
all has been exonerated already, those, has
But then
been
there's this
treated
order.
as spent on duty, Lordship. Respondent
I'm
number 3
reading
has
page
al-
28.
3 has also filed
Yes,
affidavit.
28. Here,
Respondent number 3, DSP has also filed affidavit, Lordship.
No, but what is this? Page 27 to 28, what is that?
28 for 2%, Your Honor, 2%.
2 persons.
I am for
Lordship.
serial number 1, Chongkai Boham only, not for the other.
Oh, this
That
is not for you.
Yes, Lordship.
This is not for, why you annex this?
My name is there, Your Honor, 1.
Ms.
Serial
Bhatta,
number
why you, Ms. Atu, why you annex this then?
Both of them were, Lordship,
2%.
charged together, Lordship.
Charged, 2% were charged to.
Oh, no, no, then second part you leave out.
For the
This
same.
31/8/2020, you leave out that.
For the same offense.
Hmm.
Lordship, if Lordship come to the affidavit of respondent number 3, Lordship,
Page,
page 4, 4 to 7 is 4, Lordship. Here, Lordship, accordingly, Lordship, of respondent number 3, Lordship, affidavit filed by 3, Lordship.
yes,
Accordingly, the Superintendent of Police Konsa has
Page.
exonerated
page,
page 4, Lordship. Page 4. Lordship, filed by 3, respondent number 3.
Yes.
affidavit filed by. Accordingly, the respondent, Superintendent of Police Konsa has exonerated him from the charge leveled against him and treated the period of suspension with
Okay.
effect from 8/3/2016 to 10/7/2016 as spent on duty by number so and so dated 21/11/2018. However, the petitioner Constable Chonkai Boham and did not submit their reply nor appear before the SP. Lordship, regarding them, Lordship, in page 5, Lordship,
yes.
page 5 in the Lordship.
It's okay, we are accepting it, I've striked out that, I've striked out that part. The other part I have striked out.
Lordship, here in the page 5, since the instant departmental inquiry has been finalized by the disciplinary authority, the Superintendent of Police Longding Cell initiate process for release of pension and other retrial benefits, etc. to the petitioner. That we have stated.
Okay. Accordingly, it's,
And the
accordingly,
copy of this order
in
is
para 5 of the affidavit in opposition filed by the respondent number 3, it is projected that the police authorities have moved the competent authority for release of pension and other retirement benefits to the petitioner. Next para. Next para. It is apparent. But I still I don't get it. I was referring to order dated 30 August 2022,
Lord
Ms.
sir.
Ete,
Lord sir.
and then you said that he's been exonerated, correct?
Lord sir.
The name of the petitioner is Shokai Boham,
Yes, Lord.
right? You come to page 13, page 13 of the affidavit of respondent number 3. Here it says is imposed a penalty of censure. This is something you have asked me to delete it.
Next.
Lord sir. Yes, I.
Then, and this previous order was passed by the Superintendent of Police,
Lord
and the
sir.
subsequent order is by a higher authority, and you made me delete that order.
Deputy SP, Lord sir. As per me, Lord sir. That's the second.
I don't know, because I have the lingering feeling that I have read it wrongly. But I find that I am reading it rightly. Superintendent of Police exonerated him. The higher authority
Deputy.
awarded an order of censure.
3 is Deputy SP, Lord sir.
No, I don't know. It is for you to decide who is what.
Lord sir.
Because if I am writing something in the order, then I'll make a mention that the learned on this being writing in this part being dictated, the learned additional senior government advocate says that no, that is incorrect. He's only been exonerated. I'll have to write that.
No, Lord sir.
No, that is what has happened. That's what has transpired in the courtroom.
My understanding.
No, your understanding, you see, I'm
understanding too is
Miss
that
Ete, I'm not at all bothered with your understanding.
Lord sir.
The question is that I have dictated some part of the order,
Lord
and you
sir.
said that it is incorrect. Once you say that it is incorrect and I have striked it out, I have to give reasons why it has been striked out. Because it is interference where I am dictating the order. You must have good grounds to say that. And once you have that good ground to say that,
Lord sir, because in page 4, Lord sir.
no, you see,
In page 4, Lord sir.
no, that's okay. What you write in your affidavit is one thing.
Yes.
What I am reading is something other. And I'm reading it, I am making you read it. Still you say that this is what your instructions are. Therefore, I will state that contrary to this statement, the London Additional Senior Government Advocate has made that statement.
Lord sir, in the statement is clearly said that by
No,
the
no, I
same
don't,
order
you
that
see,
is so and so.
that is for you to look out.
Yes.
What is the document you have annexed and what is the statement you are writing? It is for you to take responsibility, not the court's responsibility. I don't take responsibility of what is stated in the affidavit. I take responsibility of what I am writing in my order. And in Annexure 3 to your affidavit, the document says that he has been given a censure.
Censure, the lordship is imposed the penalty of censure. The period suspension with effect
No,
from
that is-
so and so,
that- no.
treated as spent on duty, Lordship.
That's okay, but this is what I wrote and you said that it is incorrect. And therefore I struck that out. Because if I am reading incorrectly,
Lordship, I'm sorry, that was,
no.
we have,
No, you see, you take responsibility of what you are saying. Don't travel into different boats. Because when I am dictating an order, I am I'm looking at the document and then I am dictating. So make that observation in the order. That will remain. And then you'll have to say that on this being dictated on the basis of Annexure 3 to the affidavit in opposition filed by respondent number 3. The learned additional senior government advocate has submitted that as per her instructions, the petitioner has been exonerated of all charges. Be that as it may, it appears from a reading of the documents appended by the petitioner as well as the respondent number 3 and in the affidavit in opposition filed by respondent number 4 and 6, an impression is gathered that the petitioner had constructed a house illegally within the police campus. And not studying the punishment of penalty of censure imposed. And the period of suspension was treated as spent on duty. It is a review of denial of a no objection for release of pension right. There is a document annex somewhere that NOC is not to be granted. Where is that? It is from Annexure J to the affidavit in opposition filed by respondent number 4 and 6 that the daughter-in-law of the petitioner, namely Srimati Pahi, P-H-A-H-I, Boham, B-O-H-A-M, is still pursuing BA at WRGC Deomali, and the constructed house has not been demolished till date. The Superintendent of Police Longding also, sorry, Tirap had requested the Superintendent of Police Longding that any kind of clearance or NOC in respect of the petitioner may not be issued from his office till he demolishes the constructed house from the police land at Deomali in Tirap district. Next paragraph. It is appalling to note that the police authorities, the rank of Superintendent of Police, Tirap district, has expressed that the petitioner had not demolished the house within the police lines, which reflects the inability of the state to take care of its own property. And it's surprising that the police expresses helplessness on an unauthorized construction within their premises. It appears that the state respondents by their inaction are permitting the petitioner to perfect his position over the illegal construction made within the police land. Be that as it may, if the petitioner has been possessing land illegally within the police lines, so it is open to the district administration and the police administration to take such measures as very permissible to them by law for for taking back possession of their own land. However, in this case, the respondent authorities have not demonstrated. I have not been able to show that under these pension rules, it is the governor who reserves the right.
Yes.
Governor.
Yes.
Under the pension rule 9. Show me that rule. Which rule? Pension rules. The court is made to understand that under Rule 9 of the Central Civil Services within bracket pension bracket close rules, 1972, in respect of the state of Assam, it is the right of the governor to withhold or withdraw pension. Stop. However, nothing has been demonstrated, nothing has been shown that the competent authority in the name of the governor had passed any order to withhold the pension payable to the petitioner. Full stop. This NOC business arises out of where? NOC for release of pension. This arises out of which law? So therefore, merely on the basis of a communication by the Superintendent of Police Tirak to the Superintendent of Police Longding for withholding NOC would not be sufficient to enable the respondent authorities, specifically the authorities who is concerned with the sanction and release of pension and other retirement benefits to the petitioner to withhold release of retirement dues to the petitioner. Full stop. According to the court of the constitutional opinion that the withholding of pension and other retirement dues by the respondent authorities is explicitly legal. And unsustainable in the eye of law. Next, accordingly, the repatriation stands allowed by directing the respondent authorities jointly and severally to release the admissible pension, gratuity, give a comma, pension, comma, gratuity, comma, leave encashment, comma, TPF to the petitioner within a outer period of 3 months from the date of receipt of a certified copy of this order by the Superintendent of Police Longding. It is further provided that in the event the dues are not released within the allowed times, comma, the respondent authorities would be liable to pay interest to the petitioner at the rate of 6% per annum for the first 6 months from the date of default, and thereafter the rate of interest payable would be 9% per annum. Next paragraph. Under the circumstances, the order is to cost.
May I please, Your Highness?
Yes.
My lord, I am for respondent number 2.
Yes.
I may be allowed to file counter affidavit after application.
Okay. Both sides are represented. On the prayer made by counsel for respondent number 2. Yes. Allowed 2 weeks time.
After application.
Okay. Time till first week of January 2023 to file affidavit in opposition in the matter. List immediately after the ensuing winter vacation. There's any interim order here?
But yes, my lord, I am on behalf of the petitioner.
No. Is there any interim order operating?
No.
Okay.
Much okay.
13. Yes.
May, my lord, government, they are yet to file their affidavit in opposition in this matter.
Yes.
Lordship, matter can be disposed of because Lordship, affidavit was filed on 12/10 Lordship. Our affidavit has been already filed Lordship on 12/10 Lordship. And thereafter the matter came up and this is a small transfer matter Lordship.
Yes, why was she transferred?
Lordship, she has been transferred
To
Ting Lordship. From one division to another division Lordship.
No, correct. She was transferred twice.
Yes.
So far the past transfer is concerned. The past transfer is concerned Lordship. That is the main transfer Lordship from one division to another division Lordship. The second one is the internal arrangement Lordship. Suppose one division in which section she would be. This is the only placement Lordship. And so far the past transfer is concerned Lordship. Though it has been challenged, but she has already complied.
No, but it is a different location.
Correct Lordship. Because one division within the division Lordship. Because say I am executive engineer Lordship. When employees come to me Lordship, then I accordingly arrange Lordship. This is not transfer Lordship exactly. It's only the placement Lordship. They can be interchangeably, they can be Lordship. As per necessity Lordship, they can be placed here and there Lordship. And very The first transfer is the transfer lordship.
Okay, where is the first transfer order?
Lordship, kindly come to page 17, lordship.
17, yes.
17, lordship. Lordship,
The transfer posting of
from
Kajal-
Boling division to Yingkiong division, lordship. She has been transferred, lordship.
No, you see, I am asking this question for one reason. Because the petitioner is a casual worker.
Correct, lordship.
So is casual worker covered within the, within your service rules for, so as to give them transfer from one place to another?
Yes, yeah, lordship.
Where do you find it?
Yeah, lordship, in our affidavit, lordship. Because their services are regulated by scheme, lordship. In our affidavit. Kindly come to page 18, the affidavit filed by me, lordship.
Page?
Page 18, 18, lordship.
18.
I'm taking lordship to the 12.1, lordship, down below.
Yes, 12.1.
Transfer and posting, lordship. Inter-division transfer within the same circle, lordship. That is what had happened in this case, lordship.
Oh.
Transfer of WC staff and casual workers from one
Okay,
to
okay,
another.
okay. Yes.
It's permissible, lordship.
Then we'll have to close your writ petition.
Your Lordship, I have not received the affidavit.
You have not received.
Yes, I have not received. So I was
Lordship,
waiting for the affidavit.
The same submission was on the last occasion, and here on the record, it has been shown to them, lordship. It was received by them, lordship.
And my senior, he has instructed me to.
If senior is not present, that may be another issue, lordship. Otherwise, lordship, copy was
You see
already.
this? See this? Now you need to file a suit for compensation. Last page.
An interesting point is this, lordship. So far the transfer order is concerned, that has been already complied by the petitioner.
No, that is okay, but I was thinking that it was a transfer again
Yes.
of a casual employee. You've seen that?
Yes.
Now again, this person will have to file a civil suit for compensation and damages.
Otherwise, it can be taken up. Senior is not there, lordship.
Huh.
Tomorrow.
When do you want?
After vacation, Your Honor.
After vacation?
Yes.
Is there any interim order operating?
Yes.
Interim order
interim
is-
is-
No, then we can't.
Because main transfer order has been already complied.
Then we can't.
She already joined at Yingkiong also, lordship.
Before complying, I have submitted representation to the authority.
Oh, we'll dispose it off. Don't worry. We'll dispose it off. Because if it is an inter-district, it's not an inter-district transfer, but transfer within the division. It's only an allotment of works. It does not amount to.
Your Honor, may adjourn the matter today. Let my senior.
Then tomorrow,
Yes.
list. 6/12/2020 on the pyramid and transfer to the petition.
Your Honor, interim may be continued, Your Honor.
Mr. Stapin, senior government advocate is present. List. Interim order passed to this transaction till 6/12/2020.
No issue.
14. Yes,
May I, Your Lordship?
yes.
Your Lordship, may 2 weeks more time may be granted to enable us to complete the legal heirs of the petitioner on account of the
Oh,
passing of the
petition has
petitioner.
expired.
Yes, Your Lordship.
Just a moment. Okay, joining it then.
May I, Your Lordship? Your Lordship, in this case, the petitioner has expired in the month of October 2022. And on the date 12/6/2023, the petitioner council has submitted, they will file appropriate application. But till date, they have not filed. And as per Article 120 of the Limitation Act, the maximum period is 90 days. So it's been more than so many days, your lordship. So
What is written there? In Article 120 of the Schedule to the Limitation Act. The book, I'll give it to you, don't worry. Read the Limitation Act. Please read.
May I please, Your Lordship? Under the Code of Civil Procedure 1908, to have the legal representative of a deceased plaintiff or appellant.
Correct.
Or of
Now,
a
please
deceased.
stop here. Please stop here. Now, under Code of Civil Procedure.
Yes, Your Lordship.
So, in a writ petition, I am adjudicating as per the CPC.
Yes, Your Lordship.
Correct?
Yes, Your Lordship.
Okay. And where do you get it? Yeah, I was not aware. In CPC, the CPC would apply in a writ petition.
Your
I was not
Lordship,
aware.
there is a judgment. 1996 to SSC, Your Lordship, Puran Singh, Your Lordship. 1996 to SSC 205, Your Lordship.
1996
to SSC, page 205, Puran Singh and others
to
versus
SCC
page 205. Your Lordship.
205. Mr. Tiwari,
Yes, Lord.
now you'll be in trouble. No, not that, not that. I'm just in a lighter tone. Now you'll be in trouble. If CPC applies
The CPC applies, my lord, but
in a writ petition, I'm just saying in
the
a lighter
principles
tone.
apply, my lord. This we all understand that.
No. I'm just saying in a lighter tone, without wanting a response. I'm just saying that now
If
you're in trouble.
stricto sensu, if the CPC applies, then yes, certainly will not. But since so long as the stricto sensu it is not applicable,
No, I don't
and
know.
only the principles apply.
I may be bound by the, what you call,
Indeed, indeed. I understand
142.
that.
142, I can be bound.
The observations of the Supreme Court, I don't know in what context and what Supreme Court has
I
stated.
can, no, not that, but to trouble you, I can be bound by CBC.
Indeed. These days, my lord, unfortunately, I have noted in many cases, there are sweeping, my lord, observations of the Supreme
No,
Court.
this is 99,
This is 99.
when I was, what you call, otherwise a little man. Because after those election cases, I have started using the word little man.
Yes.
9, 5. You're right, you're relying on 99 2 SCC 205.
Yes, Your Lordship.
Oh, then your reliance is misapplied.
Pardon.
Then your reliance is misapplied. Because this case relates to election petition, and in election petition, the Representation of People's Act 1951 says that CPC will apply.
Now, Your Lordship, in this case, the dependent actually dies, and the prisoner has to
It's not a
plaintiff has
case
to
of
file
dependent. This is a
appropriate
case-
application.
This is a case under Representation of People's Act. You read this 83 of the Representation of People's Act. You read 83 of the Representation of People's Act. Rules made thereunder. CPC applies stricto sensu.
Your Lordship.
But don't worry, this is
I'm
something.
submitting to Your Lordship 1996 to SSC, Your Lordship.
1996 or you said 1999?
No, Your Lordship, 1996 to SSC, Your Lordship.
Okay. I
In
wrote
this case,
1999.
Your Lordship,
No, no,
defendant
I
has
wrote
died, and the
1999. Just wait. 1996 to SCC 205.
Yes, Your Lordship. Puran Singh and others versus State of Punjab and others.
I don't know. Have you read this judgment thoroughly? You have read this judgment thoroughly, or you read only the headlines or a few paragraphs here and there?
I have read thoroughly. Your Lord.
You have read it. Come to paragraph. It may not match here. There's a paragraph starting before around six or seven. It starts with the words, when High Court exercises extraordinary jurisdiction. You got it? Paragraph 6 or 7, somewhere between it says. You give me that book.
Yes, Your Lord. Paragraph 7, when the High Court exercises extraordinary
I
jurisdiction.
read that. According to us, after 5 lines. After 4 or 5 lines, it starts again, according to us, Papa, in view of.
Yes. According to us, in view of the conflicting opinion expressed by the different courts, Parliament by the aforesaid amending act introduced the explanation saying that in section 141 of the code, the expression proceeding does not include any proceeding under Article 226 of the Constitution and statutorily recognized views expressed by some of the courts that writ proceeding under Article 226 of the Constitution shall not be deemed to be proceeding within the meaning of section 141 of the code.
Then again,
after the introduction of the explanation to section 141 of the code, it can be said that when section 141 provides that the procedure prescribed in the code in regard to suit shall be followed as far as it can be made applicable in all proceeding in any court of civil jurisdiction. It shall not include a proceeding under Article 226 of the Constitution. In this background, according to us, it cannot be held that the provisions contained in Order 22 of the Code are applicable per se to writ proceedings. If even before the introduction of the explanation to section 141, this court in the case of Bahubali versus Nandlal had said that the word as far as it can be made applicable occurring
now
in
omit
section-
those parts and come to last 5 lines. If because the explanation, if because of the explanation, so and so, It says the court says that it may frustrate Article 226, 227, because in this case, what had happened was that the legal representatives were required to be heard, just like in this case.
Yes, Your Lordship.
And now she's saying that she's making a prayer for adjournment to enable her to do so.
But Your Lordship, with due respect, Your Lordship, that limitation
No, no,
period
you
is
see-
90 days.
You see, these things doesn't matter to me because of the fact that even after it is abated, even after a writ petition is abated, I have authored a judgment where I have said that even when one was not a party, under Order 1 Rule 10 to CPC, a party has a right to make an application and get himself implemented. Correct. So despite abatement, I have my own order where I have permitted the legal heirs to come by way of Order 1 Rule 10 in the application, and the application was allowed. So therefore, that's why I said that I am I'm not bothered with that submission because of the fact that even after abatement, the requirement is you have CPC with you.
Yes, Your Lordship.
Yes. Then you see you will find a provision for under Rule 3, Order 22 Rule 3 for abatement, Order 22 Rule 4 for setting aside abatement. And this is not for nothing. 22 Rule 3 and 4. 3 is for substitution, 4 is for setting aside abatement. Read that. Be comfortable.
3, Your Lordship.
3 is abatement, 4 is setting aside abatement.
Yes.
3 is
4
substitution,
Yes, Your Lordship.
and 4 is setting aside abatement. Or 22 Rule 4.
Yes, Your Lordship.
What is setting as abatement? It is after expiry. If somebody comes, you have to explain the delay and have it abated, abatement set aside. So this thing doesn't bother me. Correct. So we are adjourning the matter. This is something which is my bread and butter. CPC is something which is my bread and butter. And when I am saying CPC, it would include 13 acts. I'm just spending time at the cost of the bar. I'm just telling you. I've made that statement earlier also. When I meet CPC, CPC would include the Civil Code Rules and Orders, the the Contract Act, Limitation Act, Transfer Property Act, the Hindu laws, Mohammedan law, Specific Relief Act, and so on and so forth. So it goes on for 13 acts. So when I say 13 acts, it for me, when I am saying CPC, this is the 13 acts. Port Fees Act, Stamp Act. Correct. So therefore, not only one part, but you have to also know the other part, limitation, not a part of CPC. When I'm saying CPC, I mean 13 acts. Also, as a duty representative, on the prayer made by learned counsel for the petitioner, the matter stands adjourned despite objection made by the learned counsel for respondent number
5 to 7. Your Lordship.
5 to 7. So as to enable the petitioner to take appropriate steps on the death of the petitioner. This after 2 weeks.
Yes, Your Lordship.
Okay. But do it in 2 weeks. You have seen the objection.
Yes, Your Lordship.
Okay.
Obliged.
Yes.
My lord,
Yes.
this application has been filed, man, for bring for review of earlier order dated 27 July 2022, my lord.
Yes.
Wherein, my lord, although full fact was not placed before this honorable court, my lord, the direction was issued to consider the case of petitioner against the reserve quota PW in Hindi. So, my lord, after passing of this order, my lord, judgment, the detailed result has been furnished to the Commissioner Education by the APSC, my lord, State Arunachal Pradesh Public Service Commission, wherein, my lord, see at page 32, it is starting from 30 and page 32, my lord. My lord, here the petitioner above.
Just a moment, just give me 2 minutes. Yes, page
Page, my lord, the relevant page, page 32, my lord.
32.
One post reserved for PWD is Hindi, my lord. And writ petitioner, my lord, was in
Yes.
my lord, third, my lord. And above him, already, my lord, two candidates they are having more marks, my lord. PWD candidate, my lord, in general, my lord, in Hindi. So as a result, my lord, because of my lord, this since there's a meritorious candidate, two meritorious candidate already there above the petitioner, my lord, that we are finding difficult, my lord. And this fact was not brought before the my lord, while passing this order, my lord, judgment, my lord. This detailed fact has been brought, has been furnished to the Commissioner Education on 16 September 2022 at page 30, my lord. The first number one, my lord, Satish Kumar Hindi, mark is, my lord, 57.4. And second is a serial number 43, marks 55.5. Now petitioner, my lord, is page serial number 45, my lord. His
No,
marks
this,
is,
this results were declared when?
my lord,
When was this result declared?
my lord, this was pursuant to the my lord, letter submitted, my detailed letter submitted by the commissioner on 16 September, my lord, after passing of the my lord order. 16 September 2022 at page 30, my lord.
Page?
Page 30, my lord. It's a forwarding letter, my lord.
But is this review petition not, is it not misconceived?
My lord.
What is the direction in this order? We say that you declare and notify the result.
My lord, result.
And then you,
Now-
and then based on that,
Yes.
you take a decision.
Yes, my lord. Now, based
take
on
a
my lord,
decision.
my lord, that is my lord, departments is of under
If you see, we have asked only to declare the result.
my lord.
After that, you take your own call.
My lord, that's
Why do
there,
you-
my
Why
lord.
do you need the High Court's permission for that?
My lord,
Did the High Court say that if somebody, after declaration of result, if somebody is.
my lord, there's a direction to for consideration of the petitioner case pursuant to the
You consider it.
my lord. Accordingly, my lord, that
No, you consider it. If somebody is, you see, High Court does not say that you consider his case, and even if somebody is above her, you remove those persons in the top and give her the appointment. Did I say that?
my lord,
Then,
it's not a case, my lord.
then you have to consider it. Consider.
Now, only my lord, problem is the my lord, they filed a contempt petition, my lord.
Definitely. You take a call, you declare a result and take a call.
My lord.
Where did the High Court restrain you from doing your job?
My lord, it was conceived by the department, my lord, that since there's a direction to consider the petitioner, my lord. So the petitioner case,
In your departments, you have advisors also.
my lord,
Every department has advisors.
my lord,
What do they do?
my lord, that is there, my lord.
No, but what do
So-
they do? If you have advisors, You have lawyers who are,
My lord-
who are
my lord.
appointed as advisors.
Actually,
After
this case, it was handled by my colleagues, my lord. Tagum Jomo. This morning, I have been handed over, my lord.
No, no, it's
So,
misconceived. Misconceived, it will be dismissed in Livini.
my lord,
The court did not tell you what to do. Court left it to you to do it.
my lord, that part is there, my lord.
No, no, this is absolutely misconceived. We're dismissing it.
My lord, can it be keep pending, my lord, for some time, my lord? Because actually this matter, it was.
No, no, it would become a handle for, we will say that at your instance, it is being adjourned. And therefore, this shall not be bar for proceeding in a contempt proceeding.
My lord,
This will
well,
not- this
well,
will not-
closing, my lord, may take observation, my lord, that part, my lord, that the department is at liberty, my lord.
Yes.
So that part, my lord. There was an apprehension from their part, my lord. That's why, my lord.
You have to think something which makes sense.
My lord,
Otherwise, there's a small poem when we were kids, we were hearing it. I think a thing, a funny thing I think. And if I think this thing, you think. You think the same, I think.
well,
Correct. So you must have some correct interpretation. If you
my
have
lord,
advisors,
yes.
you have so good, what you call, lawyers like you, more competent lawyers like you. And
Well,
they think, why do they think? Don't allow your officers to think.
well,
Correct. Heard. Mr.
T. Tagum, my lord.
T. Tagum, Leonard, counsel for the
For the state, my lord, education
No,
department.
Leonard standing counsel for the education department of the state, appearing for the review petitioners, as well as Ms. A. Anju, Leonard, counsel appearing for the respondent number two.
Secretary APPs.
This application for review is directed against the judgment and order dated 22/7/2022 passed by this court in WBC 291 of 2019. So next, by the operative part of the order under review is as follows. Para 23,
Page 27.
page
27.
25.
27.
25 to 27. Oh no, it is 27. 27 to
My lord, 29.
29. First one. Next one. The learned counsel for the review petitioners has submitted that pursuant to the order of this court, in an interdepartmental communication, the joint secretary dash capital C, small o, capital E, on behalf of Secretary APPSC, had furnished the merit list for selection and appointment of assistant professor of 2019 batch for Hindi subject. And it is projected that in the merit list, which was declared pursuant to the order of this court, the name of the respondent number one appeared at serial number 45, Whereas there are two other persons from two other PWD persons scoring more marks whose name appear at serial number
36 and
36
43.
and 43 respectively. Accordingly, it is submitted that the intention is expressed that as there are more meritorious persons than the petitioner, comma, the case of the petitioner could not be considered. The case of the respondent, number one, could not be considered. Next paragraph. It expressly appears that the apprehension expressed by the petitioners is misapplied. Full stop. This court never directed that even if there are persons higher in order of merit than the respondent number one, comma, they should be excluded. Full stop. Under such circumstances, comma, the court was of the considered opinion that the order under review dated 6/5/2022 in WBC 291 of 2019.
My lord, dated 22/7/2022, my lord. Hearing that is 6/5/2022. Judgment dated, my lord, 22/7/2022.
Judgment is 22/7.
22, my lord.
22.
22/7/2022.
Where do you get it? Where is that?
My lord, it's 15, page 15, my lord. Hearing that is 6/5. my lord.
Oh, अच्छा, बहुत भूल से 22/7/2022. Would never come in the way of the petitioner, the petitioners to consider the position of the petitioner in the merit list and pass appropriate orders for selection and appointment of assistant professor Hindi in 2019 batch as selected by the APPSC. Accordingly, who does not find any merit in this recommendation, and accordingly the same is closed. So without at the motion stage, without issuance of the initial stage, without issuance of notice on the opposite parties.
My lordship. Lordship, pleading is completed, lordships.
I think after one or two items, I'll not be able to take up other matters.
No, it's lordships.
This.
This after, otherwise, lordship.
It's okay. What do you want to say here?
Yes, lord.
I'm taking up. Yes.
Lordship, then lordship, if time, if there is no time, lordship, list this matter after.
No. Is that
If you want a lordship.
What is there?
Lordship, here is the case, lordship, additional deputy commissioner, lordships, the respondent number 2, lordships, issue a order for conducting mail, lordships, without jurisdiction, lordships.
For conducting?
Lordship.
For conducting what?
For conducting a kaba, lordship. Kaba in Nisi language, lordships, is mail, lordships.
Okay.
Here, lordship, without jurisdiction, lordships.
Okay, Civil Courts Act. Do you have any instructions in this?
Lordship, we have filed our affidavit. There is a private respondent also. They have appeared already, Lordship. Last occasion, he seek time for filing affidavit, Lordship. He sought time for filing the affidavit, Lordship.
Here is main affidavit is required, lordship, is government, lordships.
I have filed already. This may be taken up other time, Lordship. Maybe listed in admission column, Lordship.
Yes, Lordship.
Okay, yes. The Grand Counsel for the petitioner and Ms. G. Atel and the government advocate, representing respondent 1 is present. There is no representation from respondent number 3. And no affidavit in opposition has been filed by respondent from.
Lordship, private respondent already appeared, Lordship.
By respondent number 3, accordingly. For I'm just the matter is adjourned today. Interim order passed earliest and extended till the next date of listing. List after. Ensuing winter vacation.
Lordship, interim may be continued.
Interim have continued.
Much obliged.
18. Yes. Want to say something?
Item number 34 can it be taken up tomorrow, Lordship?
Just let me come to it.
May I please, my lord?
Yes, who's for respondent 4?
Yes, sir.
You file your affidavit?
No, no, no. If, I may be given the 3 weeks time to find the counter estate.
2 weeks. My lord.
But your this matter has been adjourned long on several occasions. Okay, how much time?
3 weeks time, Lordship.
3 weeks is vacation. You want to do it then? During vacation.
Okay, then 2 weeks, Lordship.
2 weeks, okay. On the prayer made by, also as a representative of the prayer made by the council for respondent 4. Matter stands adjourned for 2 weeks to enable him to file affidavit in opposition in the matter. I don't think this would be maintainable otherwise. Mr. Tiwari,
Yes, please.
I'll take your opinion in this matter.
Beg your pardon?
I'll take your opinion in this matter.
Very well, my lord.
Here what has happened, in a writ petition, the petitioner is alleging that some fabricated documents are filed. And therefore he wants a prosecution under 190, 197, 241, 341, sorry. And this is, application is registered as a criminal writ petition. I think it can't be a criminal writ petition. Criminal writ petition would normally, in my.
That's habeas corpus.
It will only be habeas corpus.
Habeas corpus.
Or anything where there's a action taken by the police or the state.
Yes, yes.
Which previously affects Article 21.
Yes.
For the petitioner is concerned. I think this writ petition criminal could not have been registered. It could have been registered as a miscase IA in that.
Yes.
In that writ petition.
Yes.
You have to get it re-registered. Can you address us? You are Mr.
And so that.
Mr. Sora, can you address us on this point? Thank you, Mr. Tiwari. Can you address on the maintainability of a writ petition? Why it should not be converted as an IA?
My lord, I am not aware actually. My lord, the senior counsel was not there. I am Khatam.
Okay. Yes, sir. Having considered that in the writ petition, the petitioner is giving a direction to prosecute the respondent number 4 for filing affidavit containing false and fabricated documents and initiation of complaint proceedings by the registry under the appropriate provisions of law. The parties shall address the court on the next date as to why this this writ petition within bracket criminal should not be closed and re-registered as an interlocutory application in connection with WPC 278 within bracket AP public 2023. This after 2 weeks.
After 2 weeks, Lordship. 2 weeks, Lordship.
Not 2 weeks. Okay. Next date we prepared to argue this. Yes.
My lord, item 22, could it be fixed, my lord, on 18th? 18th of this month.
22.
22.
Item
I hope
22.
it's 22. Where is item 22? 18th, my lord, yes.
Item 22, 18.
18th.
So 34, can it be tomorrow?
34, what is the matter about?
Lordship, what has happened in this matter is we are aggrieved by an order which is passed by the State Information Commission. Now, what the State Information Commission has done is it has issued the WT message to the police to accompany and escort the persons who had made the RTI application. There was an RTI application made by the respondent number 4 and 5. When the information was not being provided, they preferred an appeal. In the appeal, we provided the information. We said that out of the 10 questions which have been asked, a few are covered under section 818 subclause 1E and 8 subclause 1G. We cannot provide those information. And the others, we say that it is already in the public domain. We have provided the email addresses. Now, what the commission has done is commission is issued a WT directing the officer in charge of the police station to accompany, escort the appellants, so and so and so and so, into the university campus of the university to assist them and unearth the information sought by the appellants from the university, failing which appropriate action would be initiated against the authority of the university.
This tomorrow.
It has been
It
listed,
will come
Lordship.
in,
34.
supplementary list. What do you call? Oh, there are two motion matters.
Yes, sir.
Item 34 and 35. Okay, that we'll take it up tomorrow.
Tomorrow, Lordship. All right, Lordship.
This item, your item is item number
Item note 34, Lordship.
34. Oh, 34 is your item.
Lordship.
We'll take it up.
Lordship.
These two motion matters. I was not aware of this. List.
And 35 will also follow this.
Okay.
And my
Other
lord,
matters
just
will
beg to
be
make-
adjourned.
May I, Lordship? Lordship, kindly, item number
Just
27.
wait,
Lordship.
take the motion matters and then we'll go. Well, it's time to ask and comes for the petitioner. Who is the government advocate here? You will then,
K. Wangu. For 1 month. Respondent number one.
Initial is A Wangu.
K. Wangu.
A Wangu, the government advocate appearing for respondent numbers.
1.
Number 1. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has assailed the order dated.
It's a WT message, Lordship.
Huh?
It's a
The,
WT message.
order contained in a WT message dated
22/11/2023.
22/11/2023.
Three.
Comma. Where is that?
That is, Lordship, at page 111. Type copy, Lordship. The original is at page 110.
Inter alia, comma, directing the officer in charge of Pasighat Police Station to accompany oblique escort the
The respondent number 4 and respondent
respondent
number
number
5.
4 and 5, namely Sri Tagri, Tagri, Takap, Takap, and Sri Ninya, Ninya, Angu, ANGU, into the university campus of Apex Professional University, Pasighat, to assist them and unearth the information sought by the respondent numbers
4 and 5.
4 and 5. From the petitioner university, failing which an appropriate action would be initiated against the said authority, against the authorities of the
Petitioner number 1.
petitioner. Next para, the learned counsel for the petitioner has submitted that the respondent numbers 4 and 5 had sought for certain information, 10 information by RTI application, out of which certain informations were provided and the rest of the information was refused on the ground that it would infringe the rights of the affected of the concerned persons under section
81E and 81J.
8 and 81 within bracket G of
J.
the Right to Information Act.
Right.
Comma, which year?
2005.
2005.
5.
Next paragraph. Where is that act? You have a copy of the act?
Okay.
Pass it on.
Yeah.
In view of the projection that the information sought for is exempted from disclosure in the section 8(1) within bracket E and 8(1) within bracket D of the Right to Information Act of 2005. The court is inclined to take the enforcement and operation of the WT message issued by the registrar, public deputy registrar, APIC, Itanagar, under memo number APIC-764/2023/179, dated 22/11/2022, November 2023, and addressed to the Superintendent of Police, Pasighat, and officer in charge of Pasighat Police Station. In other words, the court is inclined to restrain the police personnel.
Which is respondent number 7. C is the respondent number 6.
Police personnel under the officer in charge, Pasighat Police Station within bracket respondent number 6 to enter the premises of Apex Professional University on orders passed by the Arunachal Pradesh Information Commission, Itanagar, till further orders of the court. In connection with application made by respondent number 4 and 5, namely so and so and so and so.
Lordship, 2 changes, Lordship. I had said 10 questions, there were 12 questions.
Okay.
And Lordship had noted a memo number, that is the case number.
I don't know, this is the memo number.
No, Lordship, that is the case number, Lordship. We'll find that at page.
Memo of the case of the memo number.
Case number, Lordship.
Make it case of the memo number.
Lordship, may I
Questions are 12.
Lordship. Okay. Lordship, may I pray for a stay of the proceedings also, Lordship, in APIC case?
I'm not staying the proceedings.
Because Lordship, the question which emanates, one of the questions is whether the university falls under the definition of public authority as defined in the Act. That matter,
That you raised an objection there.
that question is already pending before his honorable court in a similar writ petition, lordship, between the same parties.
Where is
That is
that?
WPC 273 of 2023.
Where is that?
Lordship, I have given it in the order copy is annexed, lordship, on your order copy.
Page?
page mein hai. Or High Court ka order copy. That is page 73, 73, 73. कहाँ है? High Court का order copy. है ना? I'm giving lordship. Written reply it is given.
Yes, if you can't
I'm
find it, you can't
providing.
wait.
I'm so sorry, lordship. It is in page 107.
107.
107, lordship. I'm so sorry, lordship. Lordship, the respondent number 2 is the 2 and 3 are the respondent numbers 4 and 5 here. And lordship, this matter is already pending consideration before this court.
Yes, as projected by learned counsel, next, as projected by learned counsel for the petitioner that the issue relating the jurisdiction of the Arunachal Pradesh Information Commission is this in respect of the petitioner university is pending adjudication in before this court under WPC in WPC 273 of 2023, the further proceedings initiated by the respondent number 4 and 5 before the Arunachal Pradesh Information Commission bearing APIC 764 of 2022.
23, lordship.
I don't know, in your prayer you said 22.
I'm so sorry, lordship. It is 7464 of 2022, lordship. I'm sorry. 22, lordship.
22.
Because, yes, lordship, because here it is given 23.
No, I don't know, you just say something.
22, lordship.
20?
22.
Okay.
764 of 22.
22. I shall remain state till further orders.
Obliged, lordship.
List of the notice returnable in 4 weeks. Yeah, just before that you write. Before the challenge, issue notice returnable in 4 weeks. The petitioner shall take steps within 2 days for service of notice on the respondent number
3, 4, 5 and
3,
6.
4 and 5 by registered post with Delhi.
And 6 also, lordship. 6 also.
3, 4, 5, 6.
3, 4, 5.
No, 6 she will appear.
Okay. 3, 4, 5, lordship.
And for one only. Only for one.
Only for one.
Yes.
But the others are government.
There's standing council.
Huh?
It's their site here. Into site.
But then we can't take up, we'll have to wait for till tomorrow then. Because copy is not served on Mr. Rintu here. No, not served. Not served, it is served only to senior government advocate.
We'll have it tomorrow, lordship.
No,
I'm
tomorrow.
sorry.
Is this matter? Is the matter? 6, 12, 23. By this time, copy of this petition is served on the learned the concerned standing council for the respondents. 35, yes.
My lord, this is, my lord, will see the e-tender notice dated 3rd October 2020, my lord, from page 24, my lord. My lord,
Okay.
Yes.
Yeah, basically it's pertain to RWD department. RWD has their own standing council.
Is it?
Council for the expired. So we.
Oh, acha.
If we
Mal-
can be taken up tomorrow, I can go to take instructions.
Then tomorrow, we can't help it.
only, my lord, my technical
No,
bit
this
has
is a
been.
standing council, we can't take up ex parte.
My lord, that's one matter. But this morning I called to the council, my lord, standing council. He telephonically he informed that he has instructed the additional advocate general Ninong Ratan to
No,
take
whatever
charge.
be, but if the council has, father is expired,
My lord, that I appreciate, my lord, that part, my lord. I'm not
same thing. Tomorrow.
only,
Tomorrow.
my lord.
Give a copy to. The copy you have, okay.
Only, my lord. Today the financial bit opened. Yesterday night, man, 6 p.m. they
Can't help it.
declared a result.
No, whatever be
And
the ground, you may have a very good case, but when there is a standing council.
my lord,
Non-service of notice will not entitle the court to give
My lord.
any order.
my lord, just I beg to mention, my lord, at number 25, my lord. My lord, this service.
This will be, they will also.
My lord, there's an interim order, my lord. That's why, my lord. Interim order may be continue, my lord. At
20?
number 25, my lord.
25.
My lord.
Okay.
Deeply. Yeah.